Good afternoon and welcome to the Appellate Division First Department. We have over 7 hours of oral argument requested. So most of you who've been here know what I'm about to say. Please ask for the time that you need, not the time that you want. Understanding we are fully familiar with your case, your briefs, the record, typically more than you wish we were. So understand that the clock is for you, not for my colleagues, so that if you are brilliant in your argument and they still have questions, I let the time roll. That being said, People versus Bernard Butts. Submitted. Talbert versus Tynes. Appellant, how much time? Okay. You haven't been here before. 6 and 2 and 6. Terminite, G. Geloni. Submitted. Lackenbower versus 162 Fifth. Okay. 4 and 2 and 4. Pescales versus Pax Ventures. Both cases will be argued together. I guess not. Submitted. People versus Jeffrey Jones. Submitted. Shanghai Pearls and Gems versus Paul. Okay, I understand the appellant is here. Okay, I think you, counsel, I am sure you are aware of this court's rules. You've been aware of them for quite some time, but I'm not going to punish your client because you don't follow the rules. So how much time would you like? Okay. And counsel, how much time would you like? Okay. 1 and 3. 3 and 1, whatever. Golden Ax Realty versus Board of Managers. And how much time would you like? Okay. Okay, 5 and 1 and 5. Robless versus 5363 Walton LLC. Okay. How much? You have a cross appeal too. So why don't you give me a more realistic number and tell me if you need rebuttal time on your cross appeal? Okay, 5 and 2 and 5 and 2, and like I said, if you're brilliant, it keeps going, okay? People versus Askia Yao. Okay, how much time? Okay. 5 and 2 and 5. Gamma USA Inc. versus Pavarini McGovern. Appellant?
5 and 2, please.
Okay.
And also, I was told by the clerk to mention, I'm not the attorney that was listed on the brief as arguing. I put in an appearance, but they said I should let the court know.
Thank you for letting me know that. Okay, so this is one of the times, so I say that at the beginning, but sometimes there are appeals that actually need a little more time. So, 7 and 2 and 8. Kaix versus Union Theological. Okay. Okay. Okay, 6 and 2, 5 and 2 and 3. People versus Jeremy Scott-Manson. Okay. All right, 5 and 2 and 5. Cardenas versus Walgreens. I understand counts. Oh, I'm sorry? Okay, you're pro se. How much time would you like? Okay, I'm going to give you 4 minutes since the other side is not arguing, and we will let you know when you can come up, okay? You can have a seat. Oh, I'm sorry. Go ahead. Okay. Well, there's no need for the 2 minutes since we have no respondent, right?
No, she's the plaintiff respondent.
Oh, okay. Say it again then. Sorry. How much time do you want? 3 and 2 and 4. Okay, Estrea versus 20 Brookner LLC. Thank you. All right. All right, 6 and 1 and 3. Gray versus LIC Development Company.
5 and 5, please, Your Honor, for appellant. For the responding cross appellant, I will take 5 and 4.
Okay, 6 and 2 and 6 and 2. People versus you're gonna have to help me with this name. Okay, and are you here for the defendant? Okay, tell me how much time you would like, okay? All right, we're gonna do 5 and 1, and I suspect it'll go to that time anyway. All right, first case on the calendar, Talbert versus Tynes. You may proceed.
May it please the court, Laura Hecht-Filella from CA Goldberg, PLLC, for the defendant appellant Brendan Tynes, who's here with me today. We're here today on an appeal of an anti-SLAPP motion to dismiss in a defamation case involving 3 tweets and a meme from 2021 that approximately 14 people saw. The lower court correctly found the lower court correctly found that the anti-SLAPP law applies. My client Tynes' statements about experiencing stalking and sexual harassment as a grad student at Columbia University involved a matter of public concern. That's not disputed. This appeal arises from 2 subsequent errors in the lower court's decision. First, the misapplication of the burden-shifting framework of 3211G, and second, the lower court's finding that the plaintiff had met this burden with respect to any element of his defamation claims. Under the anti-SLAPP law, once the defendant has established that the challenged speech is a matter of public concern and communicated in a public forum, the burden shifts to the plaintiff to show a substantial basis in law for his claims. And that means that they must provide the court with such relevant proof as a reasonable mind must accept as adequate. Here, instead
So what did the plaintiff show to demonstrate whether or not these statements were actionable statements of fact or mixed opinion? What did you feel was in the record that supports that?
So our contention is that here the statements are non-actionable opinion. They were posted on Twitter, a platform that courts have traditionally found in the broader context to indicate to a reasonable reader that their opinion. And in the immediate context, they involve slangs, typos, a meme. They were statements made on a personal account, and they were classic kind of statements that courts in this state have found to be hyperbole. The lower court, in its analysis of whether or not the statements were actionable, really just focused on our motion. And we don't bear the burden in here to show that the statements are actionable. The burden is on the plaintiff. And so in its decision, the lower court confused the plaintiff and the defendant by name at one point. In case law citations cited to Gillespie and Sharp to say that that the defendant didn't refute the plaintiff's claims, when in fact those decisions are about the plaintiff not refuting the defendant's. And they faulted our client for not including evidence when it was in fact, again, the plaintiff who had the substantial burden. And also, I would note the discovery power under the statute to get additional evidence if he needed to support his claims. In the section on actionability, it's particularly stark. The lower court never even mentioned plaintiff's motion and kind of just went through our brief and kind of picked things apart there. At the end of the day, the lower court ultimately found that neither party's submissions refuted the others, and this alone required dismissal.
So, counsel, does it matter that these were tweets rather than some other environment? How does the Twitter environment play a role in the determination whether or not it's opinion or fact?
Thank you for pointing that out, because as this court has found in other courts as well, the fact that things are posted on Twitter, which is a forum where tweets are short, and it's kind of known for rhetorical hyperbole and fiery statements and people kind of speaking off the cuff, that's a context indicator to a reasonable reader that these statements were not fact, that they were opinion.
Well, excuse me, it's especially so since your client, in response to that California article or the picture with the plaintiff with some outstanding attorney, et cetera, said she was triggered, which suggested it's an emotional response. And by the way, she didn't name the plaintiff at all, correct?
Yeah, that is correct. And I would note that the word triggered was misspelled, which is another indicator to a reasonable reader that this was not some kind of long drawn-out dissertation or a thought-out investigative piece. This was just someone reacting in the heat of the moment.
Was the alleged harm to multiple women spelled out in the tweet?
So I believe that tweet said,
That man has harmed multiple women and is abusive.
yeah, that was one of the 3 tweets in question. And again, that was kind of spoken off the cuff.
What does that mean?
Well, that,
What harm was done?
yeah, I mean, I think that goes to the heart of this as well, is that the words like harm, manipulative, those are words that don't have a precise meaning. And those are very classic opinions.
Is that a conclusion or an opinion or a fact?
I would say it's an opinion. And then I see that my time is almost up as well, but I just would also like to touch on the malice component. So one of the elements that the plaintiff had a substantial burden of showing was that my client spoke with a requisite degree of fault, which is malice, actual malice in this context. So that means that she knew her statements were false or acted with reckless disregard for the truth. And the plaintiff offered no admissions, no circumstantial evidence, no motive, nothing in the record to indicate that my client believed that she was lying when she said these statements. In fact, everything in the record goes the other way and shows why she truly, genuinely believed and what she was speaking at. And her affidavit and our evidence is the only thing that goes to her subjective state of mind that's in the record. And so both with respect to falsity and malice, I think the record is very clear here that the plaintiff didn't meet his burden.
Thank you so much.
Thank you.
Good morning, Your Honors. Perry S. Friedman, Perry S. Friedman, attorney at law for the respondent, Stanley Talbert. In this particular case, you have to look at the context when deciding whether this is fact or opinion. What happened here was there was a photograph and a tweet from Ms. Purnell saying how proud she was of the plaintiff, how he was a scholar, and complimenting him. In response, there's this tweet saying, "My stalker with the abolitionist." The stalker is, in that particular context, she doesn't say anything there. Oh, 3 years ago, he stalked me at Columbia. My stalker doesn't show an opinion. My stalker, it's her stalker. She's possessing her stalker. And then to make things even more clear, 2 minutes later, she
Isn't
tweets.
stalker a term that can be given a definition in terms of the penal code?
Yes,
So
in fact, the
if
lower
someone-
court.
I'm still
voted
talking.
it. I'm sorry.
So if someone says, my stalker, why is that not an opinion?
Because of the.
Since there's been no declaration that he was found guilty of stalking, why is my stalker not an opinion?
From just those words, my stalker, in this context, where the tweet that she was responding to had nothing to do with this whatsoever. She was introducing into this.
Have you looked at Twitter?
What?
Have you looked at Twitter?
Yes.
And responses to Twitter are oftentimes not related to whatever the tweet is about. That is not an unusual phenomenon. So tell me how the simple statement of my stalker goes from opinion to fact that can be actionable.
Well, that's the reason why I believe she felt the need to put in the second statement about how allegedly the plaintiff was harming other women and was manipulative, because this was to back up her statement that he was her stalker. This was not a matter of the cases that were cited by the respondent in their brief where someone says, this person stalked me, this person harassed me, this person did this. In that context, there was a political campaign. In this context, she's saying, how could you be with this man when he's stalking me? As a matter of fact, there were repercussions from this. Ms. Purnell no longer speaks to my client. This is in the record. She was supposed to give a lecture at my client's.
Of course, all of those things have nothing to do with our issue, which is whether the statement in and of itself,
Well,
right? And that's
audience-
our focus. So
the
all
audience
the,
believed her. The audience believed that he was stalking her
and how do we know that?
because they cut. Ms. Purnell did not.
So one person cuts him off, and now the entire universe of people on Twitter.
He also lost a job interview. Anybody who saw that tweet said this. We don't. Especially this was during Me Too. You know, they didn't want to associate with him. You know, if he's stalking this woman, they don't want to associate with him. And based upon if the modifier "my" wasn't there, if just said this guy's a stalker, that would be one thing. But my stalker saying he's stalking me, you know, he's stalking me. You know, this is a fact. And that's why the court found the way the court found. And this was also in, you know, the papers that I submitted on below. This was not something the court came up with by itself, as was implied by the respondent. My client put in an affidavit. I see I have like 2 minutes left. So let me address the malice issue. Again, here, my client put in an affidavit, the plaintiff put in an affidavit, where he stated that this room was an oval. There were no assigned seats. So where the defendant says he sat across from me every day and was staring at me, this was impossible. In fact, in the respondent's rebuttal brief, she dropped that. She said, oh, well, it doesn't matter where he sat. He could stare her anywhere, you know, changing the facts. Next thing, he was not following her. The day they spoke to each other, he was not following her. He put in evidence showing that on that particular day where the classroom was changed. So he was on his way to class. She was on her way to class. He wasn't sure where he was going. So he just approached her and said, are we going in the right direction? They looked at the maps. She knows this is what happened. She knows he wasn't following her. She knows these are facts. Then she claims that he's stalking her, yet nothing happens for 5 more months. And during those 5 months, she admits they were at parties together. There were all these places, but she doesn't claim he went up to her at any of those. One time, he says she looks nice, or she claims she made a comment about her outfit. And, you know, this was a welcome home. This was a welcome back. And at the welcome back, it would make sense he was with his friends who he hadn't seen for a while. I would imagine she was with hers. And there was no stalking taking place. In fact, when he received this email saying, I don't want to be your friend or anything more than that, and I don't like it when you talk about my outfit, stay away from me. He didn't know where this was coming from. He asked people, and that's how he found out she was accusing him of stalking. And again, 5 months go by. And I'll be done in 2 minutes. Yeah, so finishing my thought. 5 months go by. She claims that
Counsel, when I say finish your thought, I don't mean give me a factual recitation.
Okay,
I need
I'll
you to wrap
finish
it
my
up.
thought. Okay, nothing happened for another 5 months. There was a claim he was at.
All right, thank you.
All right.
You're out of time. You have 2 minutes on rebuttal.
Thank you. So a few points. One, I wanted to clarify that the tweeted issue in the lower court's decision, they quoted as my stalker. In fact, it is your stalker. So I just wanted to clarify that. And again, going back to our conversation earlier about the precise meaning of words, stalker is a term that there is a penal definition of it, but there's also a lot of different ways that people use that word in everyday life. Everything from looking at someone's Instagram or LinkedIn posts to showing up outside someone's house and following them home.
Although there's never a definition that is a positive definition for stalker. Can we agree on that? I mean, it may be her opinion, okay? But there's no good definition. There's no good perception of the word stalker. We can agree on that, right? I think reasonable people can agree that being called a stalker is never a good thing. That doesn't mean it's actionable, but it's never a good, it's not a nice thing. You're not saying anything nice about somebody who you are saying is a stalker, right?
I haven't thought through all the positive
Sure you have, but
options
that's
for a
okay. I
stalker.
understand why you don't want to answer that question.
And then second, I just wanted to, there was a lot of conversation about the facts of the case from my opposing counsel. And it kind of goes to exactly the evidence that was offered to the lower court, which was basically just a recharacterization of the interactions between our clients in a benign way. And there was no corroborating evidence to support that recharacterization, and that alone is not enough under the law. You can't just put forth a different alternative storytelling and say that's
I mean, the problem that, one of the problems you're pointing out is that the court below did not appropriately deal with the burden. So the plaintiff's burden is not like just a regular motion to dismiss, oh, we just have to find any cause of action that could have been asserted. Here, there had to be a lot more factual allegations than were in this complaint. I think that's part of your problem, the point you're making.
Yeah, exactly. The anti-SLAPP statute reflects a decision on the part of the legislature to make these cases have a higher burden because we want to protect speech. We want people to be able to speak out about their experiences, and particularly the legislative history goes to this exact type of speech. And so there is a burden there for the plaintiff, and they didn't meet it here. Thank you very much.
Lackenbower versus 162 Fifth Avenue Associates.
May it please the court, my name is Michael Kazores from the Law Office of Eric D. Feldman on behalf of the appellant L&K Partners. As your honors are aware, the lower court here granted the plaintiff's summary judgment on his labor law 241-6 claim premised on two industrial code provisions. One was 23-1.7E2, which prescribes the accumulation of dirt and debris in working areas where persons work or pass. We believe that this section does not apply and that that portion of the decision should be reversed because this area was not a working area where persons work or pass. And we were.
But didn't they have to get through that area, which was a mess, at least according to the pictures I saw, to get the material they needed to work?
Your Honor, it
wasn't just like a storage area storing things that didn't need to be used. They had to get through it.
They couldn't get through it. There was a wall right in front of them. There was a wall to the left, to the right, and right in front of Mr. Lackenbower. It was essentially a storage area similar to the.
No, it wasn't a storage area. No, a storage area has 4 walls and a door. This had no door. This was at the end of a corridor. Okay, so it's not a storage area. And it was a mess. The photographs are real clear, and we see what there is to be seen on those photographs. So I think your better argument is on the other section with respect to whether that was a corridor or not.
It doesn't really matter. With respect to the other section, if your honors believe that the first section applies. The other section is 2.1A1, which talks about
Construction materials in a passageway.
right in a
And
passage.
this was not a passageway, and it wasn't construction materials, given the description of the debris, particularly the wire that wrapped around his foot,
Correct.
et cetera.
Correct. But again, if your honors feel that 1.7 is applicable, then it doesn't matter if 2.1 is not applicable. More importantly, I guess to our appeal, given the direction that I feel that we're going here, is that we believe that the court should not.
But the direction, okay, to be clear, because I don't like that language you're using, okay? The direction is based on the evidence that we have before us. We have photographs, not of a room that is enclosed. We have photographs of the end of a hallway. So you can argue that it's a storage area and that it's a storage room, but the photographs belie that argument. So
Well-
I just want to be clear, this isn't us coming up with our own.
No,
We're basing it on the facts in the
I
record.
understand, and Your Honors, in the Deschelles case, the storage area was a wire mesh cage. It was completely enclosed, but it had a door. Our view is that this was the functional equivalent because there was a wall to the left, a wall to the right, a wall in front, and obviously there had to be an open area.
So now
to
we're going
get
to equate a
materials.
corridor, the end of a hallway is now going to become, under our case law, a storage area.
If it was being used as a storage area and workers could not pass through it because it was otherwise completely enclosed on 3 of the 4 sides.
This argument, quite frankly, is at a loss to me because under the labor law, you have to provide a safe workplace. And the way that the equipment and the materials were stored amidst all this garbage, right, doesn't seem safe to me. So I really don't understand or appreciate the nuances of this argument, but you're gonna have a chance on rebuttal to
Thank you.
explain it to me, okay?
Thank you.
All right.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. This is a corridor, hallway, and comes within the meaning of E2 by defendant's own witness, Mr. Pearson, who at 960 of the record says the location of this area was a construction floor in progress. It was a construction area in progress or a hallway. The photo.
And didn't the plaintiffs have to go through that area to get the stuff that they needed to work with?
That's correct, and that testimony is not disputed, and the photographs really tell the story. The photographs tell the story of 50 to 57 of an area that is, I don't have to really explain
Mess.
it.
Yeah, we saw it was a mess.
It's a
We all
mess.
agree.
It's a mess, and I think what's really significant, and I think this case is even better than Castaldo, with the Supreme Court properly relied on, because in Castaldo, it was a ramp, and he had trouble getting around the ramp because the hose was partially blocking the ramp. Here, you have plaintiff's testimony that he was relegated to a triangular sliver of floor that is shown in 50 of the record. It's photograph exhibit A. There's a triangle to the left of all of the material. That's the only place that he could have put his foot on. You can't see the flooring. So to say this isn't debris, it isn't scattered tools or materials under E2 is just, it's prima facie, and there's no evidence. to-
Counsel, I'm sorry.
Well, what about the other section, the
2.1?
2.1A1, the walkway or whatever? I mean, we seem to be having perhaps more problems seeing if that is a valid 241.6
That's my weaker
claim.
argument.
Huh?
I recognize that's my
That's-
weaker argument. However, I think that under 2.1, you know, definitionally, it could be a walkway, right? So we know it's not a passageway because the court held it was an E1. Could it be a walkway? Possibly. I don't have an exact case with these exact facts on point, but it could be a walkway in the sense that, and my adversary focuses on this wall, which I think is a non sequitur, but here it actually could help me establish possibly that it's a walkway because he just entered the area. He didn't even go all the way through. Is it a walkway? I'm not sure.
Could your client, could he have put down whatever he was carrying, these long boards, before retrieving it? And it sounds like the carrying of the long boards, which did have some weight to it, could have made him fall.
Well, I mean, he testified he was carrying one, I don't know, he didn't describe it as a pole. Yeah, it was one. I mean, he didn't testify that it was particularly heavy. He was carrying it. He picked it up on his way. To the extent I don't believe, he wasn't really pressed on whether it caused him to fall. He did acknowledge that he was carrying it. I mean, I think that here, I don't know if it's really dispositive because if you look at the photographs, whether he was carrying it or not, he claimed that he would have still fallen. I mean, he still had to negotiate the sliver of falling to even retrieve it. I mean, could he have put it down first and then picked up the material? Possibly. And as we know, it obviously doesn't forestall summary judgment to the effect that he may have been comparatively at fault. But our position here is that there was no fault. In fact, The foreman, Mr. Seebeck, actually said he did exactly what I asked him to do, and he's the sole witness to this, meaning there is no other way to negotiate this area. So I think
That
that
the same witness who said had he seen that, he would have fixed it because it was an unsafe condition.
that's correct. That's Mr. Pearson at 937 of the record. In addition to Mr. Thomas from Polo said, looking at photograph A, which is at 50 of the record, said this is way, quote, "This area is way too cluttered to do anything, and I would not send my workers in there to work." So yes, I think under the circumstances, a summary judgment was properly granted under 1.7E2. I also think that 2.1A1 has a shot. Thank you.
You have 2 minutes, counsel.
Your Honors, I'd like to use the balance of my time to briefly talk about the comparative negligence.
Okay.
That portion, that affirmative defense was dismissed by the lower court. As the panel knows, comparative negligence is still a viable defense, even if there's judgment in the plaintiff's favor under 241 sub 6. We feel that,
Not a 240 sub 1 case.
correct.
Right.
So given that, even if this court affirms the judgment in plaintiff's favor under 241 sub 6, we believe that the court should reverse that portion of the lower court's decision that also dismissed our affirmative defense of comparative negligence. We believe that there is at least some evidence of the plaintiff's negligence here, as one of the justices on the panel had mentioned, that the plaintiff was carrying a large metal frame, which he himself described as big. He also testified that he purposely did not brace his fall because he was holding this piece of material and didn't want to damage the material. We think that the Gamez versus Sandy Clarkson case is directly on point. Justice Kapnick and Justice Schulman were on that panel, which essentially found that a worker overloading himself with too many materials can be sufficient to raise an issue of fact as to his own comparative negligence when there's a fall. Based on all of the other factors, given the disputes between his foreman and the plaintiff about how the accident actually occurred and whether it was witnessed and other issues of fact disparaging between their two testimonies, I think there's sufficient issues of fact to show that there was at least some comparative negligence on the plaintiff's fault that should at least, in this instance, warrant reversal of the dismissal of the affirmative defense of comparative negligence. Thank you.
Shanghai Pearls and Gems versus Paul. You're the appellant?
I am not, Your Honor.
Appellant goes first. I had reserved just a rebuttal only. Oh, only rebuttal? Okay.
Your Honors, may it please the Court, Timothy Savitsky from Ovid and Ovid. By its appeal, Ultimate, or Shanghai Pearls and Gems, isn't really seeking an appeal of the trial court order. It's seeking an appeal of this court's March 2025 order. And it's not just seeking an appeal of the March.
You know that's not how this works, right?
Right.
You know that if you think that that this court was wrong on a decision, where you go is to the Court of Appeals. But we don't really think that this court is going to reverse its own court.
Absolutely not.
That's
Your
what you,
Honor. Correct.
and as a matter of fact, we already had because I was on Shanghai Pearls the last time, and we already denied the motion to re-argue. We were a unanimous panel, we denied the motion to re-argue. So it seems like now they want to have us reverse ourselves again. I mean, which we already didn't do. I was kind of confused. It was a funny.
It's two coats of law of the case and two coats of res judicata, because you've already looked at this on the re-argument motion, and absolutely no new arguments have been raised. There's no additional advancement of the law in this area that vacates law of the case or res judicata, and there's no new facts. With that, I'll reserve the rest of my time.
Thank you.
Thank you.
Got one
1 minute, so obviously I will be brief. May it please the court, I'm Ann Salisbury of Guzov LLC, and I'm here on behalf of the appellant Shanghai. And I would make one distinction here, that we are not asking the panel to reverse itself again, though it sounds like that. We are appealing the second decision of the trial court that was issued in the interim period after this court had heard the case, but had not rendered its opinion yet, this department.
But we already decided, I mean, it's funny, the procedure on this. So the judge on reargument granted, dismissed the whole case.
In the second opinion.
And then it came to us from the first opinion, and we dismissed the whole case.
It came in between.
Yeah, in between, right before the judge in Supreme Court made the reargument decision, we were deciding the original opinion. So we all came to this, ultimately, we all came to the same conclusion.
However, under 5501, and there's instructive authority from the second department.
This is such a frivolous appeal. It is absolutely frivolous. And I have heard nothing from you, and I read nothing in your papers that make me think otherwise.
I'm just citing the authority that when the appellant is no longer aggrieved, meaning they won on the court below, then the last appellate division opinion has been rendered academic. I'm citing authority for that, and it's solid authority, I understand, but I do not believe it's frivolous when there's case law. Instructive, because it's second department appellate division.
Is this the second department?
No, that's why.
Has the first department ever done what you said?
I meant, that's what I
Then
meant by
again, I
instructive.
say this is a frivolous appeal. Thank you.
I have nothing further, Your Honor.
Thank you. Golden Ax Realty versus Board of Managers. Counsel, you have 5 minutes.
Good afternoon, Your Honors. May it please the court. My name is Manu Davidson. I am with Boyd, Richards, Parker, and Colinelli. I am here on behalf of the appellant. The appeal concerns the trial court's denial of a motion for summary judgment on the fourth and fifth causes of action asserted against my client. The outcome of the appeal turns on the court's interpretation of the condominium's governing documents and the nature of the claims asserted against the condominium. There were no material questions of fact in dispute. The governing documents.
It's amazing to me that the most relevant minutes of this board are the only ones that are missing. The most important board minutes that will tell us which way this case should go, those are the board minutes that are miraculously lost.
I understand, Your Honor.
I hope you do.
Those board minutes, however, are irrelevant.
Really?
Yes, Your Honor, because the board, in and of itself, could not grant permission to change a use restriction that's specifically designated in the declaration and bylaws of the condominium. That was not disputed. Even if the board had agreed with the plaintiff that they could do the work that they did, convert the use of a daycare, of a medical office to a daycare, that action would have been unauthorized because it's not permitted, and it's not a permitted use in the governing documents.
Under what?
Under the governing documents. The declaration,
That
the
the
declaration of
board
bylaws.
could have made a decision to allow it.
That's
right?
That's not true.
Yes, under the governing documents, there is a way that this could have been put to the board and approved. So this is why the minutes are so crucial, right? Because the board does have the power to do it, and we need the minutes to see whether they did do it.
Your Honor, if I may, the governing documents specifically state that the use of a unit is specific to what's designated therein. In this particular instance, the medical office, which is
And
here.
there are other sections that talk about potential changes and the manner in which those changes can come about. So again, the fact that there are, I agree with you that the governing documents describe one daycare center and one this or that. I get it. But the governing documents also say that changes can be made if the board so approves.
Changes can only be made if they're consistent with what's in the governing documents. In other words, a board can't say, on the one hand, that a unit can be used for pet sitting services if those pet sitting services aren't permitted under the governing documents.
Well,
And Your Hon-
wasn't the plaintiff the president of the board at some point in time, so wouldn't that have mattered, or wouldn't the plaintiff have known what was required?
He should have known what was required.
And perhaps, since we don't have the minutes, we don't know if that the board at that time gave him preference or said it's okay.
We don't know what the plaintiff actually, the representative of the board president, but obviously he was bound by the governing documents because.
So you're saying that even if there was a board meeting and the board approved it, so what? Because the governing documents don't allow it. That's your argument?
Yes, Your Honor.
Okay.
And, Your Honor, if the board did approve that work would have had to have been.
This was extensive work, right?
And it also went over a long period of time. I mean, apparently the allegation by the plaintiffs in this complaint are that the board approved this work in 2009, and that it wasn't until 2014 when somebody was trying to get the C of O, that all of a sudden they say, oh, we never authorized this. What went on for 5 years there? And that's the other thing I couldn't figure out.
And nobody noticed?
Your Honor.
Nobody noticed all the construction workers coming in and renovating the place and changing it from its former use into a daycare. Nobody noticed.
Well, that's not necessarily true.
Obviously.
It was noticed, and when it was determined.
And nobody did anything about it until 6-7 years after the investment of all this money to convert the space based on permission he says he had.
Your Honors, the board, when it learned that that there was a daycare center in the facility, it filed an objection with the DOB.
So it did nothing during construction. There's construction workers coming in on a project I haven't approved, according to you. But I don't stop a construction worker. I don't go to the unit and say, what's going on here? Really? You'll have time on rebuttal, but that whole argument is just incredible. Counsel, I will hear you now.
Good afternoon, Your Honors. I'm Enrico DeMarco. I represent the respondent, the commercial unit owner in this case. Your Honor is correct. There's an issue of fact here, and the lower court correctly pointed that out. The issue of fact is that they approved this renovations. And
Sir, would you agree that the bylaws, under appropriate circumstances, permit a daycare center, correct?
the bylaw permitted daycare center, but you have to look at also the declaration, which has a more
I understand.
expansive section.
And also, it is my understanding that there's an adjoining space, F1A, which is a daycare center,
That's correct.
actually owned by the plaintiff as well.
That's correct.
So it's not like this whole occupancy is strange.
No, it wasn't strange, but he's about to purchase a unit of considerable value and make a considerable investment in renovating.
And it was, in fact, based on the affidavit submitted below,
Yes.
it was a condition to actually, to buy the unit that they would
Correct.
have approval for the daycare center.
Correct. So the process is described by both the managing agent in her deposition testimony and also by the plaintiff unit owner, who says, look, I brought the plans to the board meeting, I showed them the plans, we discussed this is part of the purchase. Essentially, he wants to know whether he can convert this unit to a daycare so that he can use it as a nursery. It becomes like a wing of a nursery.
And if they had produced the minutes,
Then it would have supported
then
his
just
position.
bear with me, then as was pointed out by Justice Manzanan, those minutes would have established the vote permissible under the governing documents for the daycare center, correct?
Yes, and
So now we have to go and fill in the gaps now.
sure. So I don't really have anything else to say. I mean, the court correctly pointed out, looking at the declaration and the bylaws together, it does permit the board to take this action. It's not like it's beyond the scope of its authority, and that's the whole issue. I really don't have anything else to add. If the court wishes to ask any questions of me, I can answer them.
Thank you.
Okay, thank you.
Counsel? I'm going to give you his leftover minute.
Thank you, Your Honor. Your Honor, I would like to cite the panel to Gabriel versus Board of Managers of Gallery House Condominium at 130 83rd, 482, 43, First Department, 2015. That court said the board's adoption of use restrictions was not a clarification of bylaws where the restriction was contrary to the condominium's bylaws. Board of Managers of Village View Condominium versus Foreman, 78 83rd, 627.
I agree that there are a lot of cases that say you've got to abide by those papers. I don't disagree with you on that.
Your
The
Honor.
problem is that the wrinkle in this case is there is an allegation by plaintiff, who's a well-placed plaintiff because he was a president of this board at one time. So he's quite familiar with how this board operates. And he tells us on his papers that it was approved, that the board fully knew about it. And so that's what we have in front of us.
Your Honor.
Counsel, can I ask you, is there anyone that controverts the affidavit of the plaintiff that there was an approval for the conversion, to alter the unit, request the proper permits, and to amend the certificate of occupancy?
Yes, Your Honor.
Who is the affiant that opposed it?
Davy Lynn was a board member at the time, 2009, when the plaintiff alleges that.
And what did he say?
He said that there was no such meeting. And
There's
even
no
if-
what?
He said that there was no such meeting, and he further attests that in order.
Well, there was a board meeting on that day, so all he can say is that that's not what was discussed, but there was a meeting.
There was a meeting, but.
And in fact, you have said, sorry, we don't have the minutes for that meeting. So
But
there
what-
was a meeting.
What he testified to was that the discussion did not go into the approval because they couldn't have approved it, right? The only way that the board could approve a change in use, which are specifically stated in the governing,
Counsel, isn't silence an approval?
it's not, Your Honor.
For all these years, nobody said anything about this construction.
It's not, Your Honor. There's a non-waiver clause in the governing documents as well. Mere silence is not
Is
enough.
there a provision that allows the board to wait years?
There's no document or anything in the record demonstrating that the board waived its right to object to the work. In fact, when the board learned about the existence of this daycare, it ran to the Department of Buildings to file the objection, which the lower
I don't know
court,
about that.
which the lower court.
Because
determined
we
was
go
appropriate.
back to, if the entire board, if none of the board members live in this building, then maybe that might be possible. But typically, board members live in the building. So it is impossible that this construction took place and no one on that board knew about it. Impossible.
I can't
But
say whether it was.
you guys will have your day in court, I am sure.
Your Honor, if I may, again, I would just refer Your Honors to records 92, 134, and 136. The declaration and bylaws both provide that in order for a change in use to be effective, it has to go to the unit owners by a vote called for that purpose. That never happened. There's no evidence in the record that that happened. And a 2009 board meeting minute is not evidence of a unit owner's meeting to affect that change.
Got it. Thank you.
Thank you, Your Honors.
People versus Yao.
Robless.
Oh, sorry. Robless. Robless versus 5363 Walton. You guys are next. My apologies.
Good afternoon, Your Honors. May it please the court. Anthony DiStefano for plaintiff appellant. If my client needed to act like Spider-Man to be able to sand the ceiling over the stairs as he was required to do, then the A-frame ladder that he was given was not the appropriate device for that task. He freely admitted that he put 1 foot on the ladder and 1 foot on the staircase railing to be able to reach 2 feet over the stairs to sand the ceiling above. And when he did so, the ladder, which also indisputably lacked rubber feet, which is what the motion court found, the ladder moved and wobbled and fell along with my client, and my client was injured. And as a result, he
So that
established...
too much weight, I'm sorry, too much weight is being placed on the fact that he had to jerry-rig his body, so to speak, to make it work.
Correct, Your Honor. As this court has held in the past, in many cases, when a worker uses a ladder in a certain manner that otherwise may seem unsafe because he had no choice but to do that, it's still a violation of the labor law because that ladder was not the correct device. So for that reason, we asked the court to modify and grant my client summary judgment on liability under 240.
Isn't it so that your client asked his supervisor, Gilberto, for another ladder, but was told there were no more ladders?
Correct. He took the last ladder in the room, and at that time, he was told that was the only ladder remaining. There were no
And the
others.
ladder in particular was missing the rubber feet.
Correct, Your Honor.
It was the shortest ladder in the group of ladders.
Of the testimony, correct, Your Honor.
Anything? Barbara?
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. David Chase from O'Toole Scrivo, representing defendants, respondents, appellants, 5363 Walton, LLC, and Sunshine Construction USA Incorporated. Your Honors, if I may. 1, 2, 3. Okay, the plaintiff had his right foot.
Counsel, I can't see what you're doing down there, and we're not in a trial courtroom, okay? Make your legal arguments.
Okay, 3 feet, Your Honors. The plaintiff had his right foot on the third rung of the wooden ladder.
The issue is whether he was provided with a proper safety device to do the job he was tasked to do. So explain to me how a 6-foot ladder to reach a ceiling on a corner without rubber feet on any of the 4 prongs of the ladder is an adequate safety device. That's the issue here.
Okay, Your Honors. So, first, misuse of the ladder is sole proximate cause. Our expert found that way. That the
We
lateral
don't get
force.
to that until you have provided a proper safety device. I know you want to jump to the let's blame the worker. But first, you have to show that you provided a proper safety device. So tell me how you did that.
Okay. So, plaintiff understood that the ladder he was using was good enough for the job. That's on 168 of the record. There was nothing on the ladder that was broken. All 4
Counsel,
legs.
asking you the same question. Isn't it true that the plaintiff testified otherwise, that he requested another ladder and was rejected?
Okay, so I can answer that question with respect to whether that was the actual ladder. So if we're going to skip the sole proximate cause argument, and go
Counsel, I want you to be real careful.
Okay.
Okay? My colleague has asked you a pointed question.
Yes.
I expect you to answer it.
Yes, Your Honors.
Okay? And I am not in any way trying to or intending to impede your argument, and I'm going to add a minute since I have had to stop you to tell you this.
Okay.
Okay? But I need you to answer our questions.
Yes.
Okay? Please.
Yes. So there is an issue of fact whether or not that ladder was actually the only ladder in that room. Okay? And so I'm going to go through some facts to show that. The plaintiff testified.
Counsel, I don't think you answered my question. Is there any controverted testimony by Gilberto or anyone else saying that he rejected the plaintiff's request for a better ladder because it was missing the feet?
Your Honor,
I don't remember any testimony controverting it.
No, there is no testimony,
Thank
but
you for
this is an unwitnessed accident. And so plaintiff's testimony is inconsistent. And because it's inconsistent, And because that puts his credibility at issue. And so there are a number of
How can there be a sole proximate cause argument if the ladder was unsafe and inadequate for the task, as my colleague just mentioned? Sole proximate cause means if there's 1% negligence on behalf of the defendant, then we look to trigger liability under 240 subsection 1.
Yes, Your Honor. So I understand the 1%. So there is an issue of fact whether or not that was the sole safety device. Okay, there were 6, 8, and 10 feet ladders at this job site. That's on 182 of the record.
All of which the other 2 were in use.
Okay, so
And I have nothing in the record that says they weren't.
there were 4 ladders in the room that morning, Your Honors. Okay, so that is on page 212. There's 4 ladders. That's on 212 of the record. Only 2 other workers had taken ladders that day. That's on 208 of the record.
Well, he did testify that it was the only ladder that was available. That's what his testimony was.
In the material room on the day of his accident, on the morning of his accident. So he said, but he also testified that there were 4 ladders earlier in that
Counsel,
material
are you
room.
saying he has to go search the entire construction project to find the ladder?
So it doesn't need to be in the immediate vicinity. That is case.
Where is the testimony that there was an available ladder? Because the plaintiff testified on page 267 to 268, it was the only ladder left within the area where he was getting the ladder.
Except that's inconsistent, Your Honors. So it's inconsistent because there were 4 ladders in the room. There were
Inconsistent
2.
with what?
His own testimony. His own testimony. So there were 2 ladders that were taken. Okay, so 4 minus 2.
You'll have time on rebuttal.
Okay, so
You will have time on rebuttal. You can take a seat. Counsel, you have your rebuttal time.
Thank you, Your Honor. Yeah, I'm not really even sure where to go with that because the testimony was very clear that there were no other ladders in the room. And although
Was there any testimony that there was another ladder in the room?
no, there was no other testimony from anyone to contradict what my client said. So if there were these ladders somewhere on the job site, as Your Honors pointed out, I mean, it's probably not cited in my papers because I don't even think this was.
It's not the plaintiff's obligation to go checking around the work site to see if maybe he could find another ladder.
Cherry versus Time Warner from this court.
And he did testify that this ladder, although it wasn't broken, it was loose and it didn't have feet on the bottom.
And it moved and wobbled prior to his fall, yeah. Unless the court has any other questions.
And after his fall, they asked him to continue to use that ladder.
Correct.
Yeah.
Thank you.
You have 2 minutes.
Yes, Your Honors. So despite the testimony that it was the only ladder available, it's not true. The morning of the accident, there were 4 ladders in the material room at 63 Walton.
Who testified to that?
Plaintiff himself, 211 to 212. But there were only 2 other workers had gone to the work areas. So 4 minus 2 is 2 ladders.
Where were the other 2 ladders?
So the other 2 ladders would have been with workers, including his own coworker who was working on the same floor as him. He knew that.
That means there were no ladders available.
But he could go to his coworker who was
tell
working
him,
Get off the ladder. I need to use it.
Yeah. Well, if it's not in the immediate vicinity, there's no reason why he couldn't have done so.
Counsel, that is just that does not at all jive with the realities of a construction site. It just doesn't. It doesn't.
Your Honor, I've never worked at a construction site, so I'm not going to opine as to
But the case law says you don't have to do that. It's excuse me, please. The case law says it's not the burden of the plaintiff to provide, the plaintiff worker to provide an adequate safety device. You have to show that there was others available. Here you're arguing based upon speculation that the other 2 were available and obviously other workers took it, so you're supposed to pull the ladder out from under another colleague, tell him to take the broken ladder, and I'll take the better one.
But
that's what you're arguing, essentially.
But I'm also saying, Your Honors, that there are other credibility issues as well. Okay, so there are other material issues of fact precluding summary judgment. He described the ladder as 6 feet, okay, with 6 rungs on 210 and 269 of the record. But he also stated that the ladder had 10 or 11 rungs on 220 of the record. So that's a credibility issue because it's an unwitnessed accident. There's also, we don't know if he locked out the braces.
Is there any case law in this department that requires an accident to be witnessed? I mean, one citation that holds that.
Okay, you are correct, Your Honor.
Thank you.
It's the sense that it doesn't require it.
Thank
But
you.
when his credibility has been placed at issue, as in the
Everybody's
case here-
credibility is at issue on every single case. But I thank you. We have your briefs and the record. Thank you so much. Have a good day, gentlemen.
Your Honors, thank you.
People versus Yao.
Good afternoon, may it please the court. Luz Beato on behalf of appellant Estrea Ya. Only by heaping stereotypes on top of stereotypes could Officer Rivera conclude that my client, a young black man leaving a NYCHA building, was moments away from shooting a rival gang.
I'm not sure it has to do with stereotypes. I think we're talking about facts that were testified to in terms of wearing a hoodie on a hot summer day, being familiar with the geography, the Crips headquarters versus the Bloods headquarters. Forgive me for using whatever
Yes.
on the record. So,
And the bulge in the right pocket.
the focus here really is the reasonableness of the police conduct. That's the heart of your central issue on appeal, correct?
Your Honor, the stereotypes that I'm referring to is labeling a NYCHA complex that is comprised of 11 buildings as being gang affiliated without any testimony as to any individualized reason that my client could be affiliated with a gang. It's just, it is a stereotype to just
Are you
label.
suggesting that officers, and that there are not absolute neighborhoods in our city that are known as being concentrated with gang activity? You recognize that that is a true statement? I don't know whether this particular building is, but that is a true statement in the city of New York and probably other cities throughout the nation,
Yes.
right?
In my experience, officers often do testify.
You
that-
haven't answered my question.
Yes, Your Honor. Your question is, could there be buildings that could
No,
be gang
my
affiliated?
question is, isn't it true that indeed there are neighborhoods, right, that are known for being high crime areas? And we know that because we've got the police data of arrests and complaints. This isn't racially motivated, it is facts based on data.
I think that the assertion that a NYCHA building, a huge complex with 11 buildings, could just be blood affiliated, I can understand if the officers are thinking some of these people have been arrested, some of these people may be in
There
gangs.
are people
but
in
the-
these buildings who are very happy that the police understand that there are gangs who penetrate these buildings. They're very happy about that because it increases the police vigilance in those communities. So that is not always a bad thing. I appreciate what you're saying. But I think that you would be better served at focusing on the issues in this case rather than starting with my client is just being targeted because he's black.
Well, Your Honor, what we have here is a young black kid and his friend leaving a building, and we're already saying that this building is blood affiliated
He
because.
was crouching
And to,
behind a car watching other gang members.
but even that assertion that these people are gang members, we don't have any information about these people. They're a group of.
So counsel, isn't it true that he had a weighty bulge in his right pocket? He was adjusting it, and then he crouches down. Isn't that reasonable suspicion for the police officer to at least make an inquiry? And then when he approaches a known gang area, and he's about to put his hand in the pocket and remove the heavy item, what reasonable officer wouldn't intercede?
Yes, Your Honor. And we have this hoodie in the summer, as you say. People wear sweaters in the summer. I do.
Bypassing the question.
But I'm.
The question is not that people wear hoodies. I could wear a hoodie as well. The question is, do you have a weighty object in your right pocket which you are adjusting constantly and about to take it out of your pocket. Shouldn't the police intercede? There shouldn't be a shooting?
Yes, Your Honor. And to your point about this weighted bulge, I know the First Department has held that an L-shaped bulge could be indicative of a weapon. The waistband is often a place where a weapon is placed, so a bulge in the waistband could be indicative. The only testimony at the court below was a weighted object. In this day and age when we all have cell phones, if I put a cell phone in this pocket, it's going to look like a weighted object.
Well, the weighted object plus the crouching behind a car and staring intently into a crowd of known gang members and wearing a hoodie on a hot day. If you add that up together, it paints a picture, doesn't it? It tells a story.
If you agree that a group of people outside of a building are gang affiliated just because, then it does color.
Even if we take out the gang affiliated group, even
Both
if
groups.
I take that out of the equation,
Then we have a weight.
right? Then I have a young man with a sweatshirt on in the middle of the summer with a weighted object that he keeps adjusting, not once, multiple times, then crouches down behind the car to observe the group at the building. They don't have to be gang affiliated. That is enough to be reasonable suspicion to approach this individual and find out what's going on. But you will have time on rebuttal to address what I just said.
Thank you.
Good afternoon, Your Honors. May it please the Court. Jonathan Gold for the Office of the District Attorney. I think Your Honors have covered, essentially that the officer's reasonable suspicions here were, in fact.
I'm sorry to interrupt. Would you agree that if there was a valid waiver here on this record, that there would be no basis to have a challenge raising the suppression ruling?
I would agree with that. I think the waiver is clearly valid. I think that the written waiver specifically spells out that that the defendant waived his right to challenge suppression decisions. So yes, I would agree completely.
Was there any infirmity in the waiver, the oral colloquy, that you wish to address?
I think that the oral colloquy here closely tracks the model. I don't believe it has to, courts don't require, a specific, litany to the letter to have those be valid. And I think here an important thing is that the oral colloquy was buttressed by, a written waiver that this court has upheld.
So, counsel, were the exceptions to the survival of certain rights that you can appeal stated by the trial court below?
I'm so sorry, Your Honor. Could I get that once more?
There's certain things that survive the waiver, correct?
Yes.
Were those instances, other than the Boykin rights, provided to the defendant before he waived?
I believe those were addressed by the written waiver
I'm
specifically.
asking you an oral colloquy.
There may have been minor omissions from the oral colloquy, yes.
Thank you.
But I think that again, that's cured by the written
Do
waiver.
you want to address defendant's argument regarding the denial of an adjournment at the time of sentencing?
Your Honor, I think the court providently exercised its discretion in denying an adjournment at the last possible stage of the proceedings. There would not.
But in fairness, Bruin had just come down, and they didn't really have enough time to review it, assess it, talk about it with the client, et cetera. So why not? What was the harm in granting that adjournment?
Well, Your Honor, they did have a week. I don't think it was no time at all. And I think that there was even in the Court of Appeals has recently held that Bruin does not overturn the entirety of New York's firearms regulations.
But then we didn't know that, right? It was a fresh case, so why not afford them an opportunity to at least assess whether they should make a motion to withdraw their guilty plea in light of the Bruin decision, right?
I believe they did have. I agree that it's not, months and months in which to do so, but I believe they did have an opportunity to assess that. And I believe that even,
Well, they haven't raised, they haven't made a motion post-judgment on that issue since the time of the sentencing, have they?
not to my knowledge, no.
So when enough of our cases have indicated that, Bruin only made a little change in the law, didn't throw the whole law out as is.
Yeah, I think that even in Bruin's original format before it was interpreted by the Court of Appeals, I think that was fairly clear.
By the way, you don't really challenge their seeking to eliminate the surcharges.
No, we don't, Your Honor.
Okay, thank you.
Thank you.
I'm going to give you his extra minute.
Just to briefly address, I'd like to address the denial of the adjournment, but I would like to address the waiver first.
Okay.
The court's flaw colloquy communicated to Askia, a person who had never been involved with the criminal legal system before taking these pleas in that context, communicated to him that he was waiving it was an absolute bar to appeal. The court first started out by saying this guilty plea is final, but more importantly, on page 16, the court says, if you could not afford a lawyer for that appeal, one would be appointed to you. You could have filed a brief and argued that a factual or legal error existed. You could have done all these things, but you're waiving your right to appeal. Also, just clarifying that this did not track the model colloquy. I understand that there's not a litany that the court has to use, but during the model colloquy, before saying that the model colloquy requires that the court explain to a client that they retain the right to appeal, what is an appeal, that they get an attorney, all of these things before telling them that their plea would be final. So it does detract fairly significantly from the model colloquy. As to your point about the adjournment, there is no procedural vehicle after Askia took the plea that he could have brought a Bruin motion. He could have brought a 440 arguing ineffective assistance, but how could his lawyer have been ineffective when his lawyer asked for an adjournment and was denied the opportunity? So there was no 330 motion that he could have filed. There was no procedural vehicle for him to file the motion. There was no harm in granting an appeal. He did not have adequate opportunity. Bruin had come out a week earlier to have this conversation. So the denial was an abuse of discretion.
Does the fact that there has been no subsequent motion by the defendant on this issue weigh for or against you?
Well, I'm the person that would have brought this motion, but on a 440 motion, which is what I could have brought, I don't understand how I could have argued that the lawyer was ineffective for not bringing a Bruin motion when he asked for the opportunity and was denied. So the only argument he has left is that the denial was an error.
Okay. What about counsel's argument that a week would have been enough time to at least make a motion to withdraw?
But the motion to withdraw was it was because of this Bruin case, and he is trying to make that motion. And I can tell you that institutional defenders, after Bruin came out, were working very hard on these motions, and it would have taken more than a week for the office. I was at Bronx Defenders. This was a Bronx Defenders case, and it would have been impossible within a week of Bruin coming out for an institutional defender, such as his attorney, to have a motion prepared, to have talked to counsel, to have something prepared to hand to the court. I think even asking for a 2-week adjournment just to bring this motion is like, he really is asking for the least amount of time that it would have taken.
Go ahead, please.
Very quickly. Did you object? I'm not you. I'm saying there's a preservation issue.
He did raise this issue. He did raise he wanted an adjournment. It was denied, and he did preserve the issue by raising this and having the court decide against him. So what he wanted was an adjournment, and he asked for it, and it was ruled against him. So that preserves the issue that the adjournment was. Yeah. If your honors don't have any other questions, thank you.
Gamma USA versus Pavarini.
Good afternoon, Your Honors. May it please the court. I'm Gregory Chertoff with the law firm of Bakar and Abramson, here for defendant appellant Pavarini McGovern. So the issue before this court is that the court below capped all of Pavarini McGovern's damages that it's asserting in this case.
And why was that not the right thing to do?
Oh, because the contract is clear. The subcontract is clear, the subcontract between my client Pavarini and Gamma, that there are, as is our pleading, our counterclaim here, that there are two very distinct categories of damages being pursued here: delay damages and non-delay damages. And the subcontract is explicit that to the extent Pavarini is passing through owner delay damages to Gamma, they are capped at $3.6 million, but that is the entirety of the limitation in the subcontract. It doesn't address Pavarini's own delay damages that it could assert, nor does the limitation address the non-delay damages, like cost to complete and correct
Was
the
it
work.
clear, was it clear that that's what you were seeking, and it was clear in your counterclaims that that's what you
Oh,
were
absolutely, and I
seeking?
could refer you to the counterclaim if I may, Your Honor. So we're starting on the record at page 501. That's the answer part. If we go forward to the counterclaim portion, which, you'll bear with me, begins on record page 541. For example, paragraph 132 of the complaint. Contractors, that's Gamma's, defective and incomplete work caused Pavarini and the owner to incur substantial costs as they perform certain repairs and corrective work, and it goes on. Those are non-delay damages.
That's not delay, that's incomplete work.
That incomplete and defective and corrective work. The next paragraph, 133, with respect to the aforementioned delays mentioned earlier in the pleading, we seek delay damages, and it goes on back and forth again and again, drawing very clear distinctions. In fact, if we look at, there are headings throughout the pleading that draw very clear distinctions between delay-related damages and not hard cost, I'll call them, non-delay related damages. So if we look there, for example, at record page 547, there's a heading, Romanet II, time is of the essence, and it there speaks about time and delay related obligations. But then the next section below that, obligations of workmanship and professional standards, defective work being performed both in their design responsibilities and their construction
So you're
responsibilities.
basically talking about section 6.1 and 22.2 of the subcontract?
Yes, Your Honor. Section 22.1, which is both in the body of the contract and it's amended in an exhibit, but it reads, and it's quoted in our brief, of course, and was cited to the court below, that provision, and you could read it, I won't bother reading to you, is the whole thing, it's very explicit. It is only limiting the subject to the cap of $3.6 million damages for the owner's delays. Notwithstanding the foregoing, Gamma's liability for liquidated damages, and that's addressed, right? The owner has the right to assert liquidated damages against Pavarini, and that's spelled out in that same section of the contract. And to the extent Pavarini seeks to assert those damages against Gamma, that limited subset of damages is capped at $3.6 million. And then if we look at the very, I'm sorry.
What does the liquidating agreement have to do with that? Does that affect it one way or another?
No, I don't think so at all, Your Honor. Separate and apart from the subcontract and the prime contract, of course, as you know, the owner and Pavarini, because they are both in agreement that all these damages were caused by Gamma, entered into the perfectly proper and well-established vehicle of a liquidating agreement, in fact, encouraged under the law of a liquidating agreement to promote efficiency in the judicial process and for the parties. And they entered into that liquidating agreement, formalizing the relationship between themselves about the pass-through not only of the owner's
Between
liquidated
Pavarini and
damages,
the owner, okay.
but all of the other owner's damages that are not delay-related. And so the judge overstepped and applied that very specific limitation on the pass-through of the owner's delay damages broadly to all the damages that Pavarini can seek against Gamma. And that is error, Your Honor. Your Honors.
Okay, thank you.
Thank you.
May it please the court, Michael Catania on behalf of Gamma. I would like to just briefly address a few of the points that Your Honors raised. Number one, it's selective what is being quoted from the answer with the counterclaim. The heading I look at is counterclaim number one, which is their sole counterclaim, which is the counterclaim that the judge below ruled upon. Every single subsection under that, which starts on page 555 of the record, talks about owner damages. The court below pointed that out. Yes, Pavarini could have brought individual claims against Gamma under numerous causes of action and under numerous sections. They didn't, okay? Instead, they entered into a liquidating agreement 4 months after a lawsuit was filed against them in which they purported to waive voluntarily consequential damages and then try to push them down to Gamma. And I would just say this. Yes, there's a consequential damage provision in the subcontract. There's no waiver specifically in the subcontract. There is one in the owner, the CMA. Two different things. A CM's consequential damages versus an owner of one of the largest projects in New York City's history's consequential damages, including lost rent, profit, et cetera, two very different things. Under the subcontract, and specifically under the definitions, the prime contract was made, part of the agreement, and we as Gamma had to acknowledge that we reviewed it and understood it. So to allow two parties to then materially change that agreement and our risk allocation after, like 4 or 5 years later and after a lawsuit has been filed, is not a proper use of a liquidating agreement. There's not a single case out there by this court or any other court that says that. Because every case that talks about a liquidating agreement says, as long as it does not affect the pre-existing rights of the third party.
So how does it do that? How do you claim that it does affect the pre-existing rights?
So prior to the liquidating agreement, Pavarini had a very broad consequential damage waiver with the owner. The owner could not assess consequential damages against Pavarini.
Where does it say that?
It's submitted by appellant, but
I
it's
thought
on
6.1 says the opposite.
I'm talking of the CMA.
So are you talking about the subcontract?
No,
I apologize.
I'm sorry. I apologize, Your
I
Honor.
misunderstood you then.
I'm talking about the
Can you
contract.
address the subcontract? Because that's really what my concern is. Why isn't 6.1 provide for damages outside delay damages?
Why does 6.1?
Why doesn't 6.1 represent damages that can be obtained other than delay damages, i.e. Consequential damages?
I'm not saying that it can't, Your Honor.
So
but
why?
Pavarini never asserted them. That's the crucial thing.
You're saying the counterclaim does not request damages other than delay damages?
No, I'm saying the counterclaim in every single point, I'll read it to you, says, and it talks about, and so does the liquidating agreement, owner's damages, not Pavarini's damages. So if you look at page 556 of the record, paragraph 194, owner incurs substantial additional costs. 195, owner was forced to, et cetera, and that's what was cited by the trial court, all of these provisions.
You're saying there's no independent counterclaim provision which independently provides for the consequential damages to anyone other than the owner?
No, what I'm saying is there was a consequential damage waiver between the owner and Pavarini, the appellant. That was part of the subcontract agreement. I'm not saying that it contradicts what Pavarini could recover from Gamma. What I'm saying is to change the prime agreement to all of a sudden allow for an owner to recover millions of dollars against a general contractor when it didn't before for the sole purpose of pushing it down to a subcontractor is not proper.
So I guess I'm not being clear. Defendants in the counterclaim, I believe, asserted other than delay damage. You're saying that's attributable only to the owner?
No, I'm not saying that at all. I'm not saying they only asserted
Why,
delay damages.
why is there a limitation on the counterclaim then? Why would there be a limitation on defense counterclaim if they asserted it? I think we're going in circles.
Yeah, and I'm sorry, Your Honor. I'm trying to be clear. It's a bit convoluted, but there
We
is
do this step by step. Is there a counterclaim by defendant seeking something other than delay damages?
on behalf of owner. Yes.
On behalf of Pavarini?
No, on behalf of the owner. That's our whole
Okay,
argument.
so if we show you it, if it's in the counterclaim where it says Pavarini independently seeks it, then you'll acknowledge it.
Pavarini has not alleged any damages on
Now
its
I
own
understand what
part.
you're saying. You're saying the owner is the only damages that Pavarini, the damages that Pavarini is seeking is only as a pass-through for the owner.
They admit that, yes.
That's your
So you're saying that Pavarini can recover on behalf of the owner from you, from your client, is capped at $3,600,000. It's a delay for the delay damages.
It's a liquidated damage, yes, correct, because that was passed through down to the subcontract.
Right, and that's it. As far as the consequential damages, they cannot recover that from you.
As far as the consequential damages, yes, because and for two reasons. One, they did not allege any independently on their own behalf. Instead, and this is in the liquidating agreement, you look how they define owner's claim, okay? It's owner's consequential damages. Owner, they negotiated, and we were bound by and read and agreed to, a part of our subcontract, a prime agreement that had a consequential damage waiver as between the owner and Pavarini. Now, to then say, okay, we're going to voluntarily, and it's in the transcript of the oral argument, that Pavarini voluntarily withdrew, allowed the owner to sue them.
And that's pursuant to this liquidating
Correct.
agreement.
Yes, Your Honor.
That's what you're saying.
Yes.
But that presumes that Pavarini limited the damages occurred only to the owner and did not seek damages in its own right in connection with the plaintiff's delays in completing the work and other damages.
Which is, yes, and that's exactly what the trial court said, because that's exactly what the pleading says. This is a motion to dismiss based on the pleading and based on the subcontract, the CMA, and the purported liquidating agreement. And that's it.
Okay.
Thank you, Your Honor.
I can't help myself. Do you have the counterclaim in front of you?
I do.
Can you read from the counterclaim, which would support, which I thought, a claim by the defendant in its own right for damages other than delay damages not attributable to the owner?
Let's just start with paragraph 131 on record page 542. It's the fourth or fifth paragraph of the counterclaim.
Well, why do I have the counterclaim on page 555, and that's where the first amended counterclaim? Is that a different
This is
document?
the verified second amended answer with affirmative defenses and amended counterclaims,
Okay.
which I'm referring. That
Oh, I
begins
thought
on
this-
page 501.
I thought this was.
Um,
Not sure.
If I may?
Please.
It recounts the parade of horribles and then says, forcing Pavarini, PMG, Pavarini McGovern, and owner to complete the work at their own expense. Right there. Our damage claims, first of all, are both Pavarini's and the pass-through from the owner. And regardless, once the liquidating agreement was
That's all you have?
No, Your Honor, I could go on, but it goes on and on.
Why can't you get something?
Contractors defective and incomplete work in the next paragraph caused Pavarini and owner to incur substantial costs as they perform certain repair and corrective work with their own resources and personnel as permitted by the trade contract, which costs are Gamma's responsibility.
You have a wherefore clause which gives a conclusion that you're seeking damages?
Of course, Your Honor.
Can you read the wherefore clause that would sum up that you're seeking damages independent of the owner?
Well, The wherefore clause just says, on the first amended counterclaim, money damages an amount to be proven at trial but believed to be no less than $100 million. It doesn't draw a
Doesn't
distinction.
attribute damages to the owner and Pavarini.
And Pavarini. And to that point, first of all, respectfully, the issue of the validity of the liquidating agreement is not before this court on the appeal. There is no cross appeal. They challenged it on the court below. The court said the liquidating agreement is completely valid. They did not cross appeal. They now want to go revisit the liquidating agreement in this argument and say liquidating agreements, which have been blessed by this court and by every other appellate court and courts all over the country for exactly this purpose, they want to argue the liquidating agreement isn't valid. They've lost that argument. They didn't bring it up on appeal. So by virtue of the liquidating agreement, all of the owner's damages are Pavarini's damages. Pavarini has admitted its liability for those damages to the owner, and thus the liquidating agreement allows Pavarini to assert those claims. The only limitation in the subcontract is that the $3.6 million cap applies to is that very small subset of the owner's delay damages that we could pass through, or my client could pass through to Gamma. There's another, and I know I'm past my time.
You are past your time.
If I may, Your Honor, because I think there's confusion here in the semantics of the difference between delay damages and non-delay damages and consequential damages and direct damages. Delay damages are not necessarily consequential. If we look at the Venn diagram, the big circle, right, we have damages. In this kind of case, we have two broad subsets, delay and not delay, hard cost, cost to complete, etc. Within the delay component, there could be direct and there could be consequential. Direct damages for delay, for example, the costs of running the job longer. My client had to have porta-johns for the workers. They're rented by the month, they're a function of time, they're a delay damage.
We got it.
Thank you.
No, that's it.
Good afternoon.
Good afternoon. Kaix versus Union Theological Seminary. Rosemont is first. Okay. You may proceed.
Good afternoon, Your Honors. Matthew Cuter from Lewis, Brisbois, Bidsler, & Smith for the appellant respondent. This case involves my client's employee. He was walking down a set of stairs. He slipped on masonite that was maintained by the general contractor. My client did not do any work whatsoever in the stairs. Plaintiff never did any work in the stairs. My client was not responsible for maintaining the stairs.
So basically, with respect to being on the hook under indemnification, because your client did not have any kind of participation in terms of establishing an act or omission that triggered this accident, therefore, that should be dismissed.
Yes, Your Honor. So this court found an identical indemnity provision in Ionitis had both a performance of the work and a negligence trigger. Plaintiff's accident did not happen in the performance of his work, and my client was not negligent. It's actually undisputed that my client was not negligent.
So it doesn't trigger, your claim is it doesn't trigger the indemnification?
Correct, Your Honor.
That you've, based on the wording of this particular indemnification claim?
Correct, Your Honor. My client's indemnity obligation was never triggered by this incident. There's a virtually identical case that this court decided recently called Sternkopf. That involved the plaintiff walking in a passageway. He tripped on some carpeting debris, and the plaintiff's employer was granted summary judgment because this court said that incident did not arise out of his work. Plaintiff's employer was retained to move some sprinkler heads. They had nothing to do with the carpeting.
So even though he was going to fetch something that he needed for the work he was doing, that doesn't make it arising out of his work?
Yes, Your Honor. That's the express holding that of this court found in Sternkopf.
I'm sorry, getting to the central issue on appeal, do you believe that the court erred in not dismissing the 241 claim and that you should have been granted Am I correct? It should have been granted dismissal on it, correct?
Yeah, so, yes, so my client is a third-party defendant, so I'm not asking you to grant me summary judgment.
It should have been granted.
It should have been granted as to the direct defendants.
Consigli.
I'm sorry? Consigli. Yeah, well, Consigli and the owner. But yeah, the argument, I'm sorry?
Why?
The argument there is that this accident happened in a permanent staircase that was not plaintiff's sole means of access.
And they had masonite that wasn't secure.
Yes.
So that's not a safe condition for workers to traverse, is it?
I would agree that that's not a safe condition for workers to traverse, but
So what fault did he have in stepping on a step with masonite that was not secure?
my argument is not that plaintiff was at fault. My argument here is that permanent staircases are typically outside the scope of the labor law, of the 241 subsection 1. There's two exceptions that bring it within the scope of that section. There's if the staircase is a elevated work platform, which this wasn't, and the lower court correctly found that it wasn't, or that the staircase was a sole means of access. And this,
Isn't there in this case, there seems to be a little bit of dispute in the testimony as to what was available. I think everybody agrees there was an elevator there, but there seems to be testimony that the elevator, even if it wasn't out of service, was involved moving some large equipment, and the plaintiff was just standing there and waiting and waiting and waiting and waiting. He had to get his work done. I mean, he couldn't wait forever for the elevator, so he went to take the stairs.
I need to just clarify something on that point. Plaintiff's testimony was that he went to the elevator first, he realized it was busy, and then he continued on to the stairway. Plaintiff's affidavit, which I argue is self-serving and should have been disregarded, speculates that there was some sort of major delivery that lasted for...
We don't know.
Well, he didn't know.
We don't know, and the record doesn't tell me that the elevator was indeed available.
Well...
Do I have an affidavit from someone saying that at the time of his accident, that elevator was not in use by other workers? Do I have an affidavit saying that at the time of the plaintiff's accident, the elevator was not in use?
No, Your Honor, but we do have...
Well, isn't that an issue of fact?
No, Your Honor,
Why
if I
not?
may. So...
No, you want to rest on a daily log for that date. It doesn't show that the elevator was taken off service. That's what you're relying on.
Not only that, but yes,
He
that
didn't
is...
say it was taken off service. He said it was being used. That's different.
If I may.
So even if a log, if there's no mention in the log, I doubt that construction sites log every time an elevator goes up and goes down.
Respectfully, Your Honor, in this court's opinion in Caba, that plaintiff and his supervisor waiting a half an hour for an elevator that never came, this court still described that elevator as available. This plaintiff was waiting for an unspecified amount of time, and frankly, I don't believe that, if the elevator comes by, he sees people in there, and then the elevator continues. I don't believe that
We
that's...
don't know. You are making statements that are not part of our record, right? All speculation.
What we have in the record is Mr.
What I
Price.
have in the record is a man who falls down a flight of stairs because the masonite that was more important to protect the floor, but not the worker.
Your Honor, so there was other available means of access as well. There were two other
I don't
staircases.
know that either.
It's
Was
not
there-
actually in dispute that there
Was
were two
there
other
was there any testimony as to where those elevators were? I mean, did he have to walk like a half an hour across the hallway to get it? I mean, was it in the middle of the construction? I know there's testimony that there were other elevators, but were they anywhere in the vicinity of where he was working?
So the testimony is that this was in a wing of the incident. The accident happened in the north stairwell. There was a central and a south. There was not specific testimony about the distance
How far
between
or where?
those staircases, but it's my position that it's plaintiff's
So if
burden.
the worker is working in the north side of the building, and he was going to get his painting equipment, excuse me, and he had to go from the fourth to the second floor, and he waited for the elevator, and he says, it wasn't going there, and I'm proceeding to use the only means of getting to the second floor, which was the staircase.
Which was one of the three
which was the staircase. So again, based on based on the question posed and your response, it suggests an issue of fact. And we have case law that says that when there's the very issue you're raising, namely the possibility of other means of access, and there's a debate about that, and that's called an issue of fact, which would warrant denying summary judgment.
May I respond, or should I?
Quickly.
Okay, Your Honor. My position that it's plaintiff's burden to establish that there are no other available means of access, and counsel did not even attempt to do that with respect to the other staircases. Thank you for your time.
Okay. Now, you moved to dismiss the plaintiff's 240 sub 1, right?
Yes, Your Honor.
And when you move, it's your burden.
Well,
You can respond when you get up, but when you move, it's your burden, not his.
thank you, Your Honor.
Next.
May it please the court, John Shore for plaintiff. First of all, in the lower court papers, their argument was that a permanent stairway is not a 240 so 1. They
But
cited
that's not true, is it?
that is a complete erroneous statement of law, which the lower court pointed out. They cited to a litany of Second Department cases.
Well, you don't need the Second Department, the First Department, and De Silva made it clear that a permanent staircase can be covered by the labor law.
Not only that, in the Conlin case, which Justice Mansonet sat on, that made it very clear that it is a 240 so 1. And respectfully, counsel is actually misstating the record. As Justice Mansonet pointed out, there was no affidavit from anyone actually to controvert plaintiff's affidavit. The lower court acknowledged that there was no inconsistency in plaintiff's affidavit and plaintiff's testimony. In fact, no one asked plaintiff why the elevator was busy, and the affidavit simply amplified the testimony and said, had I been asked, I would have testified that there was a delivery going on. And similar to the Caba case, it's the same premise. In that case, they were waiting 30 minutes because there was a delivery. In this case, my client testified that.
Did that case create a bright line rule about 30 minutes?
I wouldn't say.
How much time is too much time or not enough time to wait for an elevator to go do your job? Did we create a bright line rule?
No, you did not, Your Honor. What is absolutely reasonable, there's no one who disputes
Counsel,
the
in fact,
testimony.
in Caba, the court granted summary judgment to plaintiff. It was the opposite.
Well, in all these cases, the issue is whether or not the work was not only the sole means of access and whether it constituted an elevated related risk. There's some other cases where, like in the Solati case, where they said there was a question of fact because there was a dispute in the testimony whether the thing broke, the step
And you
broke.
addressed one case, I know it was cited, Games, G-A-M-E-Z versus Clarkson. There's actually an interesting quote in that case. I'll read it to you. The citation is 221 AD 3rd 453. It's a First Department case from 223. Given the existence of other means of access to the work site, there's an issue of fact as to whether the staircase that plaintiff descended constituted a safety device under Labor Law 240 subsection 1.
I actually, right, I have the case before me. Thank you, Your Honor. In this case, they
Isn't that all fours? Isn't that the same situation?
Actually not, because in this case, all you have is the testimony of Mr. Plasek, who, in his testimony even about the daily reports about whether work was done, he said, I have no specific knowledge. He has no personal knowledge whether or not that elevator was out of service for any particular time.
How do you deal with the other two staircases? He was on the north. I believe there's a center and a south staircase that he could have taken, other than the elevator. Wouldn't that at least create an issue of fact?
Respectfully not, because my client testified that He was not aware of any other
Was he
staircase.
directed to use any particular staircase if the elevator was not available?
No, he was not, Your Honor. There's nothing in the record, but
And more importantly, was he directed and told not to use that staircase?
absolutely not.
So he didn't ignore a directioned order by his employer to not use a particular form of egress and ingress, correct?
Absolutely. And I would submit to you, Your Honors, that this case is actually far more egregious in certain respects than some of the other cases, because here the record is uncontroverted that there was no protection provided for the worker. It was protection for this big, very expensive renovation going on, and that caused my client, which is uncontroverted and documented by his employer, who identified the photograph even, that this was, this masonite caused his accident.
Thank you.
Thank you, Your Honor.
May it please the court. Good afternoon, Your Honors. My name is Kevin Murtaugh, representing the owner and construction manager in this case. I only want to address one point in my brief, which is the indemnity argument. That's the only thing we want to address. We believe the court was correct in its decision below not to dismiss the.
Well, what's the issue when counsel was up discussing it, he said that plaintiffs did not, that the indemnification claim, the indemnification provision was not triggered by anything that happened in this case. How do you think that it could possibly be triggered so as to make us go along with the
Yes, Your Honor.
trial judge?
What's not before this court, of course, is the fact that no one disputed that there are 241-6 claims out there. There's no doubt about that. So under those circumstances, those still are present. So it's possible that there could be a finding that there was comparative negligence on the part of the plaintiff. I know there's no comparative negligence on the part of 240. So what I'm saying, Your Honor, is that under those circumstances, our indemnity agreement passes muster under Estrea Brick.
Counsel, did you raise that argument in your papers? I don't recall that argument.
What?
That there are other remaining causes of action, so therefore the indemnity clause should stay.
No, I did not. No, I did not.
I would have remembered that.
Yeah, I'm sure you would, Judge Hackler, having been before you
That
many
surprised
times. But what I'm suggesting to you, Your Honor, is that you could search the record. There's no doubt about it in the pleadings in here that there is a 241-6 claim. That was not, no one moved against that, Your Honor.
Right.
No one moved against that below. So it
Is there a 200 claim remaining?
I'm sorry?
Is there a 200 claim remaining?
There is a 200 claim remaining.
Even better.
Yeah, even better, yes. There's a 200 claim remaining, Your Honor. There's no doubt about that. So what I'm suggesting...
That would have been your best argument.
I'm sorry?
That would have been your best argument.
Well, 241-6,
But the
200...
issue,
Well,
I'm sorry, but the issue,
Yes, Your Honor.
whether Rosemont, you're seeking contractual indemnification from Rosemont.
correct. Yes, Your Honor.
Okay? And the issue is whether they did they do something in this process, an act or omission, that triggered this accident. Now, we know that Consigli, based on this record, did everything. They inspected, they put the masonite down, they did it all. And if you're found liable under 240, then because of Consigli's actions here, then it doesn't implicate Rosemont at all, because where is the act or omission that played a role in this accident?
Well,
You're resting on the fact that the plaintiff is an employee of Rosemont. He was the actual victim in this accident, and therefore that triggers this indemnification clause.
there
That's
was-
your argument.
No, in addition to that, Your Honor, there could also be findings here that Rosemont was negligent. There's no doubt about it.
How were they negligent?
How could they be?
What facts are there here to assert that?
The fact that he was not given another area, another means of ingress or egress to go down to go down those.
You have masonite,
Masonite.
probably on all the stairs to protect him from all the construction.
I don't know about that, Your Honor. I don't know. I don't know about that. I don't think that's.
We only care about the marble on the north staircase, but not in the center or the south. Counsel.
Yeah. Yes, Your Honor.
I mean, that just doesn't even make sense.
No, but Your
right?
Honor, there's also an issue here of whether or not that indemnity agreement, do I have to show negligence on that? Judge
There is no
below showed-
negligent trigger in the
There's no
language of
negligence
this
trigger.
agreement.
That's it, Your Honor. We're claiming there's no negligence trigger on the part of the indemnity agreement.
But there
Okay,
is
but you
something
don't-
you have to show, and you have not shown it.
No, I don't, no, we have to show that, we'd have to show, Your Honor, that certainly, yes, it would arise out of, would arise out of the agreement, arise out of the work. Yes, it would have to arise out of the work, and this would certainly arise out of the work that he did. That's what we are claiming, Your Honor.
Walking down the stairs is
Your
arising
Honor.
out of the work.
Doing the work that he was doing, Your Honor, yes.
He had to get downstairs.
Thank you.
All right. You have 2 minutes.
Thank you, Your Honors. Briefly, the Ante case established that identical indemnity provision had both a rising out of and a negligence trigger. There is neither here. I don't know what counsel's arguing. I guess I'm supposed to build a new permanent staircase to allow my clients to walk up and down. I don't understand it. With respect to the other causes of action, which admittedly, they're still in the case, plaintiff's comparative negligence are defenses to all those causes of action. So there's really, there's
Well,
no basis to.
Are you resting on the note, I'm sorry, are you resting on hearsay speculation that the plaintiff was running down the stairs?
No. I'm just trying to point out the fact that counsel is able to assert any defenses he wants with respect to the other causes of action. In order to establish their indemnity claim against my client, they have to both establish that it arose out of my work, and if Your Honors agree that the 240 action should be dismissed, or if you agree with my argument that, that the indemnity provision has a negligence trigger, they have to establish my client's negligence. They can do neither. With respect to the insurance,
You procured the endorsement. You procured the endorsement paid.
I got the right insurance. The lower court said I got the right insurance. For some reason, it said I got the right insurance for the GC, but not the owner. I don't understand the distinction there. I'll rest on my papers on that argument. With respect to the 240, I'm just going to make the argument anyway, because I know where, seems that's like I know where this is going. But the position my position on the 240.
I don't speak for everybody. I only speak for myself.
My position on the 240 issue is that generally permanent staircases are outside the scope of 240. Plaintiff has to establish that 240 is applicable here. So I met my prima facie burden on 240 by demonstrating that this accident happened on a permanent staircase. The burden shifted to plaintiff to establish that that permanent staircase should be considered a safety device under the statute, and they failed to do that.
Thank you.
Just one question.
Sure.
Just want to make clear that the affidavit by the project superintendent.
Mr. Plasek?
Yes, you submitted that in opposition to plaintiff's motion, correct?
That affidavit was submitted in opposition to plaintiff's motion in response to plaintiff's affidavit that was submitted for the first time during the motion practice, yes.
Okay, that's when the other two staircases were mentioned.
That's not the first time, but it is mentioned in that. Mr. Plasek also mentioned plural staircases during his deposition testimony.
Thank you.
You're welcome.
You have 2 minutes.
Thank you, Your Honor. In the Kaba case, they granted summary judgment in favor of the plaintiff for the same reason about the unavailability of the elevator. And I submit to you, Your Honors, that
Isn't Kaba distinguishable because there are two other staircases that could have been used?
Actually not, because it would defeat the purposes of the Labor Law Section 240 So 1. The same thing with a ladder in a similar case that was argued before. It's not the burden of the worker to start searching for other ladders or other staircases. Clearly, the staircase here was an elevated
Kaba,
device.
I believe the supervisor directed the plaintiff to go down the staircase, so therefore we have a direct command. So obviously the worker had to accede to that command. We don't have that here.
It respectfully does not matter. In the Court of Appeals case on the Bianca NATO, there was no specific directive and there was actual safety violations, but it was the custom and practice. Here, the worker never knew about the other
There's no custom and
staircase.
practice, right? He was only there for, I think, 1 day.
He was there for 2 weeks. They were using the elevator. of his de facto boss, Mr. Membrano, who actually said there was only one staircase on page 372 of the record, which does not matter, said they would use the staircase. But it's not the burden of a worker, and the record is uncontroverted here, despite this affidavit saying, well, I looked at the work logs, but I don't see anything. He was there, Mr. Plasek, supposedly. He could have submitted an affidavit in his affidavit saying, you know what? I was there. There was no elevator out of service. He did not, because if he did, there potentially could have been issues of perjury on his part.
Thank you.
Thank you, Your Honors.
Made a mistake.
People versus Jeremy Scott-Manson. You may proceed.
Good afternoon, Your Honors. Mary Catherine Smith from the Legal Aid Society on behalf of Jeremy Scott-Manson. The prosecution has already conceded that Mr. Scott-Manson is entitled to resentencing in this case. This court should also vacate Mr. Scott-Manson's convictions and remand for a new trial. There are two issues that I would like to focus on today. First, the missing witness instruction, and second, the Sandoval ruling. Starting with missing witness, the trial court...
Missing. She was uncooperative. There's a difference. She was in their office and told them, notwithstanding the videotape of her being beaten for over 15 minutes, that, oh, I think that might be me. Oh, I'm not really. This is a domestic violence victim who was beaten to a pulp, right? Calls 911 during the attack. Names the defendant by name, gives his address to the police. This is not a missing witness. This is an uncooperative witness.
Your Honor, respectfully, the court's ruling below was based on materiality. The court specifically said she does not meet the qualifications of a material witness. And this was based on the prosecution's representations from that conversation with the complainant, in which she told them, that might be me on the video, that sounds like my voice. She also told the prosecution, this is the worst Jeremy has ever hurt me, and she remembered being chased around the car by Jeremy. So she said things that indicated that she both remembered and didn't remember parts of the night. And the trial court below, even though arguments were made by the parties about control, and I can certainly agree that there are facts on both sides of the control issue, but what we have here is a ruling based on materiality. And so that's what we have to work with. And that was an error below, because she's very clearly a material witness. If we look at the People v. Kitching in the Court of Appeals, a material witness is someone who is in a position to know what happened, to testify. And this complainant is the victim in the case. She's obviously in a position to testify.
What do you do with a witness who comes into your office and says, I don't remember anything? So we put her on the stand to say what? I don't remember?
Your Honor, it was the prosecution.
I'm asking you.
Yes, Your Honor.
Put her on the stand to say, I don't remember.
And they could impeach her with her prior statements. They had those. Instead, they made a strategic decision to not call her, and then it was in the hands of the trial court.
So, counsel, there weren't other evidence to substantiate that claim that your defendant beat this woman 10, 15 minutes, kicked her in the head and in the face? There were no other evidence.
There is other evidence in this case. There's video surveillance evidence from different standpoints. There's also the complainant's fresh statements soon after the incident. But this error, which, you know, I think now we're getting into harmless error.
Even if it were an error, let's say I agree it might be an error, why is it not harmless in light of the overwhelming evidence of this beatdown?
There were a few different ways that this harmed the Mr. Scott-Manson receiving a fair trial. The first being that in summation, the prosecution remarked on that testimonial evidence from the complainant, and that counteracted, respondent in their brief points out that the defense did remark in summation about the complainant not being called. But without legal instruction from the court, jurors were met with equivocal argument from both sides. One side saying, you heard from her, the other side saying, she wasn't called. What do you think about that?
What typically happens in a criminal case when a court does not think that a charge is appropriate, but doesn't want to prevent the defense from asserting their defense. So we allow you to make your arguments, and you were allowed, not you, but counsel was allowed to make the arguments about her being missing. Wouldn't you expect her to be here? I thought those were all very good arguments, and they were permitted.
Yes, Your Honor, but without legal summation is not a proxy for the judge telling the jury that they can draw the inference that the prosecution would have called this witness if she was favorable to them. And I think there's no question that that's true here.
Why isn't it dispositive that the prosecution didn't control the victim?
Why is it?
Why isn't it dispositive? Why do we have to deal with materiality? Why do we have to deal with any other factor? How can the prosecution drag a victim into court to relive something that the victim does not want to testify to or may be afraid to do so?
If I may go over. What we're limited by here is the trial court's ruling. The prosecution below made some compelling arguments about control. Yes, you are. Under La Fontaine and the Court of Appeals.
The issue of control was raised.
The issue of control is raised, but it's not in the ruling.
Right, when the both of you are talking over each other, I can't, that's not real helpful, and it's usually better for you to wait.
I understand.
I'm gonna give you the time to say what you have to say, but talking over my colleague is never a good thing.
Thank you.
Okay? So you'll have time on rebuttal.
Excuse me, may it please the court, Milan Chachanda for the people. I just want to start off with noting that the court specifically noted on multiple occasions that there were several reasons for why she was denying the missing witness charge, including the primary one that she did say would not provide relevant testimony. But you have to understand, this case where control was a huge issue and argued extensively, it was inextricably intertwined with why she would not.
Am I correct that the people in this case never had control over this witness?
Yes, Your Honor, because
In fact, you were able to get a grand jury indictment without the complainant taking the stand in the grand jury.
exactly.
Right? So you had to depend on the testimony of officers who responded to the scene, videotape, I would imagine, and medical evidence, correct?
Absolutely.
Because she did not testify in the grand jury.
And that is one of the distinguishing features from the cases my opponent cites. In like Kitching, the court specifically says control's not an issue. In Kitching also, the court didn't even, people didn't even have to explain why the witness was not in their control or unavailable. And control never comes up in these issues, and they're unsubstantiated allegations, where here you have a substantiated, her absence from the grand jury, among other things. And she's, a record of how many times she's come to court in favor of defendant, her presence there, and her refusal to testify for the people. And again, I think Your Honor mentioned, not only shouldn't we put on a witness who might claim not to remember, but in this case, the prosecutor was adamant that she believed she was lying. So I think it's it would be almost unethical for the prosecutor to maybe place a witness on the stand that she believes is lying, is concocting a false narrative.
Counsel, can you address the Sandoval ruling appeal? Basically, we all know that it's a balancing act that takes place in terms of your right in the event there's a plaintiff decides to testify, that you could impeach him by prior convictions, et cetera. You want to talk about that?
Sure, and I think this is a classic case of a great compromise in that, as the people requested, a menacing misdemeanor conviction was not, the court precluded any kind of reference whatsoever. And with respect to the assault conviction, which was precisely the most closest analog
to the charges in this case, the court only allowed the prosecution to refer to a broad, unnamed misdemeanor. And with respect to the 2 felonies, didn't allow, as the people requested, the underlying facts. Now, the court had to do some balancing of the people's need for effective impeachment, especially in a case like this, in which you're going to have one sole defendant, if he were to testify, giving a narrative, and balancing that with whether the prejudice would far outweigh the probative value. And as Sandoval itself says, the probative value of violent acts is pretty significant. And again, one thing I do want to mention is that a defendant should not be insulated from impeachment of prior violent crimes if they have a tendency or a pattern of committing such crimes. As in this case, I think the court did a balancing of precluding the one that was most close to the charges here, but you can't be insulated from a pattern of crimes if you're committing crimes of violence. So unless there are any further questions, I rest in our brief. Thank you so much.
Briefly, I just want to apologize for my conduct earlier, sincerely. I'd like to respond first to the missing witness argument and then Sandoval. Under LaFontaine, the appellate division should review issues that were actually decided against the defendant, not alternative grounds for a ruling. And I think a second point that I wanted to get to about harmless error with that issue is that in summations, the prosecutor was able to comment on what this complainant said. That was evidence that they brought in. But they chose to bring a case where this witness was never subject to cross-examination. And that is a missing witness, and that's part of the intention of a missing witness instruction, is to instruct the jury that they can draw an inference from that. And just briefly on Sandoval, I'd like to...
The statement that you're referring to is the statement that she made in reporting the crime.
Yes, Your Honor. In regards to Sandoval, I'd just like to note that this was, as Your Honor said, a domestic violence case. And the conviction for attempted strangulation is very evocative of domestic violence. It suggests to anyone who would hear that that happened in a domestic violence context. And so to have that be impeachment evidence really would have just told the jury that Mr. Scott-Manson had a propensity to commit crimes of domestic violence. And there was also a 2013 burglary that was allowed to be asked about, and I think that that could have served as sufficient impeachment evidence for the prosecution to use had he testified.
Is that the test? Whether it's sufficient impeachment evidence or whether the court has to look at somebody's record, look at the facts of the case before them, and as has been said repeatedly, strike a balance so that they don't get convicted for past crimes, but they also don't walk in sanitized and lily-free when they have had a life of crime, right? So there's got to be a balance of the two, but I appreciate your arguments. Thank you, ladies.
Thank you.
Cardenas versus Walgreens. You can have a seat here. You may proceed.
Good afternoon, Your Honors. May it please the Court, Xingyue Yu here for the appellant Duane Reed, sued here as Walgreens. This court has consistently held that a plaintiff who voluntarily left a position of safety to get involved in a physical fight assumes the obvious risks inherent in that activity. Here, assuming what Mr. Cardenas alleged in his complaint is true.
Well, let's talk about, because I wanted to be clear what we're talking about here.
Okay.
Right? So Walgreens has one of its employees being brutally attacked, violently attacked, stabbed. And this man acts as a good Samaritan, tries to help your employee, and now you're here saying you shouldn't have jumped in, too bad that you got stabbed and got hurt. Case dismissed. Do I have that right?
Your Honor, we are...
Is that the position of Walgreens? That their customer, who came to the aid of one of their employees who was being brutally stabbed, that too bad, you should not have been a good Samaritan and helped.
Your Honor, during Reed or Walgreens, we have the duty to protect our customer, but that duty is not unlimited. We are not insurer or guaranteeing of the safety of our customer. Mr. Cardenas was...
Counsel, 2 words, rescue doctrine.
Sorry?
2 words. The rescue doctrine says the other way.
Rescue doctrine. So the suspected shoplifter is having a confrontation with the security guard.
And stabbing your security guard.
Yes.
Right. I mean, let's call it what it is, right? So I am shocked that we are here, okay?
Your Honor, respectfully, this filing of this motion to dismiss is meant no disrespect, and we are...
Well, I'm not saying it's disrespectful.
Yes, okay, but under the doctrine of primary assumption of the risk...
How about the rescue doctrine? Are you familiar with that?
Yes.
And why doesn't that apply here?
Mr. Cardenas, yes, he has the duty to make sure he's safe first. And then his intervening act severs the causal
So you're going back to assumption of risk. In the rescue doctrine, it's the reverse, that there is liability upon the defendant if you come to the rescue as a good Samaritan. That would release the assumption doctrine. It's the opposite of the assumption doctrine.
You'll have time on rebuttal.
Thank you, Your Honors.
Mr. Cardenas?
Good afternoon, Your Honors.
Why don't you lift the mic so we can hear you and you don't have to stoop down?
Good afternoon, Your Honors. My name is Jacques Cardenas.
It's your voice so we can hear you.
A
little louder.
I have a tough time breathing due to the loss of the left lung from the stabbing.
I'm sorry, okay.
So don't want to feel like I'm shouting. The motion to dismiss was denied by the court in its entirety. There was no legal error in law. My complaint set forth valid claims on its face. There's no more to add. Besides, I wasn't breaking up a fight as the defendants claim. The gentleman was being stabbed, and either I ignored it, pretended I didn't see what's happening. He killed him and then attacked the woman that was behind him that was stuck in the exit. I had to do the right thing, and that's all. So due to it,
Sir, are you representing yourself in the
yes,
entire
yes, Your Honor.
litigation?
Yes, Your Honor. So due to it, the lower court made a decision, and I'm just here to confirm the lower court's order. I have nothing more to say. I lost a good part of my health. My life has been shortened because of it. And they're just trying to sweep it under the rug as it's a normal Tuesday. So I'm losing my hearing on the left side from it, nerve damage, all from the stabbings. I can no longer do tattoos, which was my main profession due to the stabbing. I'm going to need numerous surgeries throughout the rest of my life. They said there's nothing they can do to stop the hearing loss on the left side, and I don't know what more to say.
How many times were you stabbed, sir?
Stabbed me over 12 times.
12 times.
5 times left shoulder. The first 2 were the defensive wounds when he tried to stab me in the neck when I blocked. 5 times in the left shoulder, 2 times to the left back, plus the little cut. So about a dozen times or so, Your Honor.
Okay. Thank you. Counsel?
Your Honors, if I remember the rescue doctrine clearly and correctly, if the security guard is trying to sue Mr. Cardenas, then he has the Good Samaritan law to say, I'm just trying to rescue you, so I don't have, but it's not the duty on
Focus.
Walgreens.
Counsel, the focus here is whether Walgreens adequately protected its customers. And in this process of the plaintiff attempting to rescue a security guard, and had they had greater security there, it may not have resulted in that. That's the issue here. That's what the rescue doctrine is implicated here.
And really, this is just a motion to dismiss on the pleadings. The court, the Supreme Court found that he had made out a claim. You may be able to bring up your affirmative defense later on, but that's not really an affirmative defense on a motion to dismiss. It's more summary judgment. So, I mean, I think that's what the judge found below.
Well, first of all, the Supreme Court didn't really give us any explanation why they.
She found that he stated a cause of action.
That's all the court had to do on a motion to dismiss under this ground.
Which I don't think the Supreme Court specifically say there is a cause of, like, they didn't specify.
By denying your motion, the court is saying the pleadings are sufficient, counsel. It's implicit in denying your motion.
Okay.
Okay?
Okay.
All right, you have something else you want to argue? I don't want to stop you.
I'm done. You want yours?
Okay.
Thank you.
Thank you so much. Estrea versus 20 Brookner, LLC.
Good afternoon, Your Honors. My name is John Haig from Hoffman, Madeline Monroy, and I represent the defendant appellants in this matter. By way of background, this case originated, it's a putative labor law case, 241 sub 6. But there was a lot going on in this case. Initially, it was in the city part because there were municipal defendants. There was another client of mine that was impleaded. We answered for them. This was going for...
This has been a proverbial schlep, right?
Correct.
So the issue is whether, at this juncture, notwithstanding a perception that you're not complying with all the compliance orders and just getting your act together and waiting to get the deposition done and getting the documents exchanged, et cetera. The bottom line is there a basis to move forward or not, or is the ultimate sanction appropriate? That's the whole issue here.
That is.
You can't deny the schlep.
Our position is that the ultimate sanction that was provided was the most draconian sanction the court could have given.
Well, it was, quite frankly, coming. How many times does a court have to order something before you do it?
It was not, Your Honor.
It was.
The PC order had multiple defendants.
The PC order is not signed by a judge, that's an order.
It is, and the plaintiff was...
And you adjourned it 3 times.
No, Your Honor.
Yes. You adjourned the court-ordered depositions 3 times.
Those court-ordered depositions were not just adjourned by my office. The city was in on it. There are different municipalities.
All I know is that the defendants were the ones asking for the adjournments, not plaintiff.
Well, I am not the only, or I was not the only defendant in it from the beginning.
Okay, that doesn't help you too much, but go ahead.
Well, the plaintiff also did not go forward with a lot of these depositions. I mean, the plaintiff...
I'm sorry. Wait. Don't go there, because the plaintiff is the only one who actually has sat in the deposition chair. Am I correct?
You are.
Okay. So why you would say anything about the plaintiff with regard to depositions, I don't understand, since they're the only ones who have appeared.
Well, after the PC order, the plaintiff impleaded one of my other clients that I then answered for, and then we joined these cases.
So what? Was it impleaded parties that you knew existed so that it wasn't a surprise when they got impleaded? I ran a discovery part, counsel. I know how this works.
Okay.
So the fact that there's a new party that gets impleaded from a contract that you had from the very beginning and knew all the universe of potential people who could be sued, is not an excuse.
Well, Your Honor, the issue here was the plaintiff's employer. We impled them. And eventually, we had to then go back and implead them again and implead them under multiple names because the plaintiff was paid in multiple checks by different providers. So and eventually, we got them, and we did a tender, and there was an acceptance. And that acceptance was 3 or 6 days before the plaintiff filed this discovery motion. This discovery motion in which he sought to strike the answer, among other relief, that was 4 weeks after the plaintiff's deposition was finally completed.
Right, because it had been adjourned 3 times at the request of the defendants.
Well, some of those requests are also because there weren't sufficient records. There's a lot of things going on in a case. And there were a lot of moving parts in this case. It was in the city part that
I saw the little attempt to judge shop. I don't like what one judge is saying, so let me go to another part and see if I could get a better answer. Counsel, this record is replete with the defendants playing games on discovery. Replete.
Your Honor, I have to disagree.
Replete. I ran that part for a whole year. I know exactly what goes on in that part.
Your Honor, how is it judge shopping when the plaintiff was the one that brought in the municipalities and then the municipalities had to fight to get out? And then that brought us before Judge Suarez's part, who this motion was originally before. And because I had the pickup by the sub and I expected the file to be transferred, I messed up and failed to calendar the return date. And the second I realized that, I emailed Judge Suarez's part, but he was retiring. Then we get a letter saying, okay, this has been assigned to Judge Socorro. 3 weeks later, I'm in her part. I make an application. She denies the application. First time on, denies the application.
Tell me what that application was.
For leave to place.
You wanted to adjourn once again, right?
I wanted leave to place.
You weren't ready on the date of the conference, and so let's delay it some more, Judge.
Your Honor, it wasn't a conference. It was the motion return date, and there was no op file because I failed to calendar
a motion
properly.
return date is a conference so that you can orally argue, and you did not have responsive papers, so you were not ready, and were seeking an adjournment. Isn't that what happened?
I could not place papers because I missed the initial return date because I failed to calendar. That was a law office failure.
So the answer to my question is yes. You weren't ready, and you didn't have responsive papers. Once again, another delay.
Your Honor, it wasn't about delaying.
But there has been exorbitant delays here. We will hear you on rebuttal. Counsel, I'll hear you now.
Thank you, Judge Michael Prisco, for the respondent. The court brings up an issue of whether the sanction was proper. And before you can reach that issue, the issue needs to be decided, well, what is the proper vehicle for the appellant to contest that? Here, they have made a motion to renew and re-argue, but those, they make a motion to vacate, but they can't make a motion to vacate because it's procedurally improper at this point.
Assuming that we consider the original motion that Judge Socorro granted was on default, because as defendant is saying here, he miscalendared it. It was law office failure. There were no papers that were submitted. He asked for an adjournment on the return date. The judge said no, so she granted your motion. I don't know if I forget if she used the words on default, but she certainly said there was no opposition no opposition was submitted. So it was granted on opposition. Isn't the appropriate thing for the defendant to do under those circumstances to move to vacate the default? Isn't that what they have to do in order to appeal in the event the judge says no?
Yes, if it was a default order, the proper procedural mechanism to move to vacate.
So why would you say it's not a default?
Because it wasn't on a default. It's conceded in the record, page 117. The defense attorney was present at oral argument. He made an application for an adjournment.
That wasn't on the record.
It wasn't on the record, and it wasn't, I gather that his opposition was really not on the merits. It was, Judge, could I get an application? The answer was obviously no, so that's what happened. And as my colleague said, that was not on the record that I could find.
It was not on the record, but at page 117, there's the affirmation from counsel who explained what he was allowed to do at that oral argument at paragraphs 4 and 5, and he was substantively allowed to present the same arguments that he is now presenting before this court. But assuming it is a default order.
I'm not sure.
The court didn't address it.
I thought the judge said, I'm really not considering his arguments on the merits. I'm really making a judgment.
The October order, the underlying order, it said that there was no opposition filed.
Right.
Opposition papers
right.
filed, but not that it was on default or that the attorney wasn't allowed to argue his position. But assuming
you recognize that they weren't conceding this. It's
yes.
clear they weren't conceding, so it's really a default. And when there's a default, they get an opportunity to put an excusable default, which is lawless failure, which is recognized, and a meritorious defense. They can do that. That's what's going on here.
May I have a little extra time? Assuming it was on default, there's still another issue or another layer before you get to the merits of whether the sanction was appropriate. They would have to be entitled to the default, which they would have to show that they had a reasonable excuse for not putting in opposition, for not defaulting. And the excuse that they're saying is that they didn't calendar the return date, but that's contradicted in the record.
Office failure is not a good reason, as what you're saying.
It's not a good reason. It's also contradicted in the record. There's an email at page 130 that was sent to the motion court judge where they were saying the reason that they didn't file the opposition was because they anticipated they were giving the file away. But that is an unreasonable excuse because this insurance carrier dispute was well known to defense counsel, and they were hoping that this file came off of their plate. It, in fact, never got off of their plate, so it was wholly unreasonable. After 2 adjournments of that motion, too, by the way, up to the 60 days, so there was no more adjournments allowed, for them to just put this aside and hope that the file was going to be transferred. That was unreasonable. They cannot establish the reasonableness prong. And then just very briefly, if I may.
That was the same reason the insurance carriers fighting over who's going to pay for what was the very reason that the depositions kept on getting adjourned and adjourned and adjourned because nobody wanted to pay for the deposition.
Exactly, and that's why the excuse of not calendaring the date is not reasonable because they're saying they didn't calendar the date because they thought this file was going to be transferred. But why would it be a reasonable belief that it was going to be transferred before this upcoming return date, this imminent return date, where this carrier dispute has been ongoing since at least early October for several months?
We've all been trial judges, you know us from there. We've all heard these things a million times amongst us, I'm sure. We feel, or at least I feel your pain, but there is, in New York, we try to hear the cases on the merits. I mean, this is the severest sanction that there can be. There may have been, I understand all the things that you're saying. It is kind of frustrating, but given that, you think that there's nothing that they've put in there to allow them to continue on with the case, and you should just get an inquest for damages against them?
I think under this record where you have, for example, you have a motion for sanctions filed in October of 2023. You don't have oral argument until March 27, 2024. It's transferred through several judges. They don't even make an attempt to put in opposition, even though it's late, and then show up at the oral argument and request that the judge, there's no prejudice to the plaintiff at that point. If they put in opposition, they would have had sufficient time to put in a reply. It would have been a full record. They could have done that. They didn't do that. There's no evidence in the record that they attempted to contact the plaintiff's attorney from October of 23 to March of 2024 saying, hey, we know you have this motion pending. Let's do the deposition. Let's do the deposition.
Other than plaintiff's deposition, what discovery has transpired?
By the time the motion was made?
Yeah, at this point, to date.
Oh, the note of issue is filed today.
Okay. Yeah, but that was filed without the discovery,
Yes, the only outstanding discovery at the time of the note of issue was the defendant's deposition.
the plaintiff's deposition.
No, the
Defendants. Plaintiff had been deposed in April of 23.
So defendants have not been deposed.
Defendants have not been deposed.
Okay, all right.
There's been a physical exam?
There has not been a physical exam, and I don't believe there has been a physical exam. I'm
Okay.
like 99% certain
Okay,
of
sorry.
that, but
Okay, thanks.
All right, counsel.
If I may, the judge in denying the initial motion and in denying my application, in her decision, she also says that there was no excuse provided. So what I did tell her, she disregarded, which was part of the reason why I wanted to renew. And the renewal was really the opposition. And if I had placed an opposition, I don't think there's any doubt that this sanction of having the answer struck would have ever occurred. More importantly, what I raised before the judge was that the good faith requirements, and I've had motions denied in the Bronx where the plaintiff and the defendant are completely in opposite sides seeking disparate relief. And I've had those motions denied because there was not that good faith letter saying that we tried to communicate with each other and we could not possibly come to terms with anything. And the case lawyer says that it's not enough just make one email or one phone call. You need to actually converse, and that it has to be futile.
So your position here is your friend didn't do a good faith attempt here to resolve the discovery dispute.
You also,
Wasn't the-
yeah, I mean, you forget that you,
Unbelievable argument I have ever heard.
I mean, look, remember that also you delayed it for years and years.
Well, the delay wasn't mine.
I'm gonna delay while the insurance companies decide who pays for an EBT and discovery. And I'm going to backlog the plaintiff's case because insurance companies should dictate how we move our cases in our courts, right?
No, that's not it, Your Honor. But the problem is,
Apparently, because how long, for how many adjournments did you ask for while they fought with each other over who paid for what? Meanwhile, the plaintiff's case stands still.
2 adjournments of the motion.
4 adjournments of the EBTs.
Those
2
were-
adjournments of the motion. Should I continue? Because I'm sure if I go through the record, I'll find more.
Your Honor, the problem here is,
The problem here is that you're trying to pin on the plaintiff the obligations and the lax work of the defendants. That's the problem here.
may I?
I didn't ask you a question.
Okay.
Thank you.
Um,
Thank you. Gray versus LLC Development. Justice Chan is recused on this case. Should there be a tie, we will follow appellate division procedures and vouch in a judge. Okay?
Very well, thank you. Roger Sacker, Newman Ferrara, LLP. May it please the court. I can't imagine a case where you aren't already familiar with many of these arguments, but I'll jump right in. Let's turn to the early occupancy agreement. The analysis starts with the 2023 Burroughs opinion from this court. Justice Schulman, Justice Kaplan, you were on those panels, or on that panel. The court specifically said that what we need to do is we need to look at the pre-HSTPA version of Fact Sheet 40. So that's where we need to start. Court of Appeals said the exact same thing. We're going to look at the applicable guidance at the time.
They at least affirmed us on that.
They at least affirmed you on that. That is true. So let's look at Fact Sheet 40 as it existed with respect to this early occupancy agreement.
So we know in the early occupancy agreement, if putting aside whether it's void, and I'm not going to go there right this second, the issue is whether concessions are preferential rents under the fact sheet and which fact sheet controls. That's the heart here.
Not precisely, Your Honor. Bear with me just a sec. The issue with Fact Sheet 40 is that this early occupancy agreement predated the lease term. Old Fact Sheet 40, pre-HSTPA Fact Sheet 40, says only concessions offered during the lease term count as not being preferential rents. So if we are going to construe Fact Sheet 40 strictly, which I think we should do, this early occupancy agreement doesn't count and cannot be must be taken into account when setting the first rent. With your Honor's permission, can I get to the void versus voidable argument? So, waivers of rent stabilization. We know this. Riverside Syndicate, Liggett v. Lou Realty, which I argued at the Court of Appeals. Waivers of rent regulations are void. This early occupancy agreement says on its face, rent stabilization doesn't apply to your apartment.
What about your friend's claim that there was no harm, no foul, allegedly?
It doesn't matter. That would make it void, not voidable. Or that would make it voidable, not void. I'm sorry, got that backwards. Sorry. So and they did benefit. They got to register a rent that didn't take into account this early occupancy agreement. So with that, let's turn to the post-HSTPA concessions. Justice Hagler, Justice Kapnick, you were on Veal. We've had these arguments before. The post-HSTPA fact sheet 40 has totally eliminated this concession preferential rent issue. HSTPA is clear, preferential rents must be renewed. You cannot use rent concessions to circumvent HSTPA. And it's all the more egregious here because they get $20 million each year to follow the rent regulations. They've never done it once. With that, I'm happy to answer any questions. Thank you.
Good afternoon. May it please the court. My name is Matthew Brett from Belkin Burton Goldman for the respondent, appellant, owner in this case. I'm going to dive right into this because I think this is really one of the main issues here. It's what counsel left off with. The definition of preferential rents has not changed with the HSTPA. Now, how do I know that? This court said that. This court, with two of the justices here, Justice Kapnick and Justice Shulman, you specifically stated in the first Burroughs case, which was affirmed by the Court of Appeals, that if the legislature had wanted to change the definition of preferential rents, the legislature could have done so. And that has never happened here. And I know that there's been a lot of static about fact sheet 40 being silent on concessions. Well, owners cannot be guided by silent concessions by agencies. It creates a problem. I'll remind this court that we have been battling since 2008 over the J51 issue, where owners were actually following the explicit rules of the agencies and then were penalized for it. Now, owners are supposed to be clairvoyant and supposed to know when agencies or the legislature changes a policy silently. And this has really just been something that's come up. I know it came up in Viol. Arguably, Viol, with all due respect to the judges here, was overturned or was basically abrogated by the recent Burroughs decision from December 2nd, and also the Court of Appeals decision, which basically said that if the legislature wanted to change the definition of preferential rents, they could. And I will submit to you that if you look at the old definition of preferential rents prior to the HSTPA, and you look at the new definition of preferential rents after the HSTPA, and you look at it in both the RSL and in the Rent Stabilization Code, the definitions are 100% the same. The only thing that changed in the HSTPA with respect to preferential rents has to do with the issue of whether or not they can be withdrawn or continued. That is the only change.
No, that's not accurate. Under the HSTPA, the preferential rent is really the legal regulated rent, and you can't have an artificially higher rent with the preferential rent.
I agree. I agree. I'm not saying something different than that, Your Honor, unless I'm misunderstanding what you're saying.
Okay.
The definition has not changed. The exact same.
No, but before the HSTPA, the preferential rent was not necessarily the legal regulated rent.
Correct. Before the HSTPA.
That's a huge difference.
Well, before the HSTPA.
Forget understanding what a preferential rent is.
Right, but the HSTPA, what it changed was it said that an owner can't withdraw the preferential rent.
I understand.
So it becomes, yes, it becomes their legal rent for the duration of their tenancy. So with respect to that, though, but the actual definition of what it is hasn't changed. And one thing, and this is why I think if you look back at your Burroughs decision, where it specifically said, had the legislature wanted to change the definition of preferential rents to include concessions, that the legislature could have done so. The legislature's actually tried 2 times in legislation.
You can't rely on that.
No, but the fact is that if the definition had really changed to include concessions now as part of preferential rents, they wouldn't need a legislation to say that it has to be registered as a preferential rent now.
What about the discussion that counsel was having with Justice Shulman about whether or not the early occupancy license agreements are void or not? I mean, what is your position on that?
You know, I'm kind of perplexed by this argument because all this, there is an agreement to allow a tenant to move in early before a rent-stabilized tenancy has started, right? Okay, and they're getting free rent. So I'm trying to, and your question about the no harm, no foul, I think is a valid question. I think that the end of the day is that the agreement, if you're going to avoid the agreement, what does that mean that you're avoiding this agreement that's specifically attached to a rent-stabilized lease? Every single early occupancy agreement is given to a tenant that is getting a rent-stabilized lease. All it is doing is saying you can move in earlier. There's never been a situation, at least with this owner.
But you understand that if you're moving into a rent-stabilized apartment,
yes,
you cannot say, okay, I'm going to evict you on a 10-day notice to quit.
But you're absolutely right.
And you can't say you have no right, because the mere stepping over the threshold makes them a rent-stabilized tenant.
Absolutely, but that never happened in this
Does that make
case.
them void? So does that make these agreements void?
I don't see why it does, because we have agreements that, like, let's, for instance, a rent-stabilized lease. There are provisions in rent-stabilized leases that we probably would all agree are probably not enforceable, right? They have language in there that may not be enforceable. We don't have a situation here, and I would agree with you that if there was an attempt to evict somebody in that month or two before the lease period, that would be a violation, absolutely. But that didn't happen here. That's not part of this record. The record...
So, counsel, you're really arguing that you can have a rent-stabilized situation without a rent-stabilized lease at the outset of the tenancy? Wouldn't that be void? You can't have, there's no such thing as a rent-stabilized tenancy without a rent-stabilized lease that is in conformance with the law.
And when these tenants all got this early occupancy...
But the EO says that this is not a rent-stabilized lease, this is a license, and we could do X, Y, and Z. Why isn't that black-letter law that that's void? What other scenario can there be to permit such a situation?
Sure. I would submit, Your Honor, that this court has in multiple times, in multiple scenarios said, it's not what the agreement says, it's what the arrangement is, right? You have said here that you can't waive into rent stabilization. I'm sorry, may I finish? You cannot waive into rent stabilization. You cannot create it by private agreement. Even the case that counsel cites, the Union Square case, says, don't look at what it says, look at what it is. And it's a rent-stabilized tenancy from the start. You can't evict them. They'd have to get all the purposes. Even if it says something, it's inartfully drafted. It is still a rent-stabilized tenancy, not one of them. And all they've gotten is a longer term. They've gotten 14 months as opposed to 12 months. Thank you.
So, counsel, can I ask you something? There's some reference in the briefs to an argument about rent increases that were taken at unauthorized lease intervals.
That's what, and that's what he was right. You're talking about, rent stabilization. We all know this, right? 1 year or 2 year. Well, now they're manipulating it. 14 months, 16 months, 11 months, 13 months. This is why this is so important. We have to, if we don't, and this is, I quoted at the end of my brief, a second department decision that talks about how landlords can come up with all sorts of ways to manipulate the rent regulations. They're supposed to be strictly construed. It's the only way that we protect tenants. And it's all the more important here because over the lifetime of this tax credit, they will save hundreds of millions of dollars that were supposed to afford tenants rent regulatory protections, and they were not here.
Can I ask you about boroughs? Are you... counsel had argued that boroughs essentially had eviscerated our decision in Viol. Can you talk to that?
So look, if you read Veal carefully, read all the paragraphs where it's talking about boroughs and all of this, throw them all away. I know you worked very hard on that, but let's throw them all away and but keep those last two paragraphs that have nothing to do. I think it's the last two. I don't have it in front of me, but it talks about fact sheet 40 and COVID and all of these things that we are talking about here. Even if you get rid of all of that, you still have the early occupancy agreement problem and you still have the post HSDPA rent concession problem. It's still there. Thank you.
Thank you.
Thank you.
You have 2 minutes.
I have 2 minutes. I'm gonna use it to.
Yeah.
2 minutes.
It was okay. So
I'm a little bit.
Everybody wants me to leave.
confused. So, you are asking us to just, what are you asking us to change from Judge Bluth's decision?
The only thing we're asking to change from Judge Bluth's decision, we think she got it right, and everything was the post-HSTPA concessions being preferential rents. And I think the key reason here is, and I want this to go beyond just the four corners of this case. During the pandemic, there were concessions being given by hundreds of owners. Maybe that's not compelling, but it was what was happening at the time. And there was a reason for it.
Yeah.
You had services and amenities that couldn't be used, right? And so this is a perfect case because this is a luxury building that had a movie.
Can't go to the gym, you can't go to the pool.
Right. So the question I have then is, if that's a problem, then what about if we didn't give those concessions, but a tenant stopped paying rent during the pandemic, and we brought a non-payment case, and we gave them a 2-month abatement? Would that be a preferential rent? So all we're doing here is we're acting out, prophylactically to basically stop this problem that was a problem that we all know it happened. I think we can all take judicial notice of what was happening in the city at that point in time. So I do think that the issue about post concessions really is it's a bigger issue than maybe it is here. And there is going to be abuse by owners, admittedly, but in this particular case, all the owner did for a period of late 2020 to late 2021 was give concessions because of the pandemic. And it's documented in the record below that that's what was happening. And so I don't think that that's the thing that you want to punish owners for. What would be the alternative to that? As to the early occupancy agreement, council made a point about this 1 or 2 year lease. Well, in Flynn, which was this court's decision, that was a 13-month lease. May I finish? I'm sorry. That was a 13-month lease, okay? Giving a tenant 2 extra months on their first term doesn't hurt the tenant. It gives them a longer time on a lower rent. It's exactly the opposite of that. How is a tenant harmed by saying, we're going to give you 2 months for free, you can move in, and then we're starting?
What rent is registered with DHCR? The higher rent, right?
The rent that's registered at the DHCR is the rent. It is the rent in the lease. If it's a preferential rent, it'll be registered as a preferential rent. What is not registered is a concession because, as I mentioned earlier, they tried to change the law to have that registered, but it has not passed yet at any point in time. Thank you. Now we can go.
Now you can
invite
leave.
Justice Chan back in.
People versus Ionitis. Sorry if I mangled the name.
As long as she didn't have to pronounce the first name also.
Yeah, I'm not even going to try. You may proceed.
May it please the court. My name is Lauren Reisig from Cravath, Swain & Moore, and in association with the Office of the Appellate Defender, I represent Mr. Athanasios Ionitis. Mr. Ionitis was denied a fair trial when the court admitted significant evidence about a prior uncharged gas system without engaging whatsoever with the required Molyneux analysis.
But we're not debating that a Molyneux analysis is applicable, but it seemed clear that the judge gave limiting instructions throughout that the flex hose, I'll call it the flex hose system, is not at issue in this case or in your client's case. It's the background to explain how your client as an unlicensed plumber proceeded to rig the system historically, was called on it, and chose to recklessly proceed, albeit with steel piping, to continue to rig the system. And that's not unreasonable in this context.
So you're right, the judge did give limiting instructions, but those limiting instructions missed the key piece here, propensity. This evidence was being used to show propensity of the defendant.
State of mind.
But state of mind.
That's not propensity.
So all of that goes to Molyneux. Molyneux, the reason that there are rules where you balance and limit this evidence is because you are worried that the jury could improperly infer propensity from that evidence. This was a prior bad act, and because of that, the defendant acted in conjunction, consistent with that bad act.
It's sort of, I know you were probably sitting here most of the time, and we had a few cases ago the discussion about the Sandoval, same type of thing. The judges have to weigh the different factors, pro, con, prejudice against probative value, and come to point in the middle, they give it a limiting instruction, and, that's what it has to happen. It's not the perfect result, but that's why there were rules. Again, it seems that you can't just jump into the last situation that happened without explaining how it got there. And it seemed that the judge tried to make it clear to the jury that, what happened, the explosion was because of what happened on March 15th, 2016, or I've gotten that date wrong, but what happened on that date, and not what was going on before.
So 2 responses, Judge. First, the judge in the trial court didn't actually recognize that this was Molyneux evidence at the first place.
Yes, I understand. So you're right.
So he didn't engage whatsoever in that balancing that's required, and that's the issue here. There was no discretion, no limiting.
Was the result the same, notwithstanding the lack of verbalized analysis, right? Because at the end of the day, as my colleagues have said, all that limiting instruction was precisely to strike a balance between this prior bad act and to the extent that it was background information, because he had been working on this for a while. So quite frankly, it's part of the res gestae of the case.
I think what's key here is that looking to the charge itself, there was a proper Molyneux charge given immediately preceding the one about the flex hosing. When they're talking about the building code violations, the judge tells the jury, you cannot consider these building code violations for the propensity purpose. You can only consider it for background, for those other things. When it comes to the next instruction about the flex hose system, all he says is this is not part of the charge conduct. That essentially invites the jury to use this in exactly the way that Molyneux is designed to prevent. They're not supposed to infer that just because my client previously built one gas system, he improperly built a second one. And that's the key piece here. And because of that limiting instruction was not proper, that prejudiced my client and denied him of a fair trial. And it wasn't just that they admitted some evidence. They admitted significant evidence. There were 8 different witnesses, 2 of whom spoke exclusively to this prior gas system. They talked about how it was dangerous. And then they admitted photos, a phone call.
I don't understand why that's a problem. This building blew up because of the faulty and defective system that was put in place. And it could have been avoided had the defendants here heeded the first warning of Con Ed that what they set up was illegal, unsafe, and hire a proper plumber, right? So that seems perfectly legitimate evidence in this context.
I realize my light is
Yes, of course.
That you're getting at right here, that is the propensity inference we're concerned about. That because
you call it propensity, I call it the fact pattern leading up to the explosion. You can't, I don't see how the prosecution, how it could have been expected that the prosecution should be allowed only to submit the evidence of the work done on the explosion and not the warning ahead of time that what you're doing is unsafe. That's absolutely relevant to this case. I don't understand.
Would you like me to?
Yes, please.
So even so, this prior system was used different materials, different piping. It had different faults.
By the same unlicensed person.
And that
the one thing that they kept saying is hire someone with a master plumber's license. Those are the only people entitled, legally allowed to do this work in the city of New York. So, but you'll have time on rebuttal.
Absolutely. Thank you, Your Honors.
Good afternoon, Your Honors. Sylvia Wertheimer for the people.
Do you concede that the judge missed recognizing this as a Molyneux issue and engaging in the normal analysis that one would normally require for a prior bad act?
Respectfully, I think it was part of the single course of conduct. Started with the flex hose system, whereby,
Course of conduct from how many months ago? Come on.
well,
They took that system apart and replaced it with the system that blew up. This is not,
on the same day, okay? The same day that the first system generated a gas leak, that afternoon, defendant and the co-defendants got together and decided to create this second, more elaborate system.
Was that because Con Ed was coming in that day to do an inspection? Was that
Excuse
the
me?
day?
No,
Or
that was
a different
that
day?
was long before
Okay.
Con Ed was coming in to do the inspection. The failure of the flex hose system underscored the danger of creating a gas delivery system without the mandated safety review. That's what the crime was here. And you could not possibly have, the jury could not possibly have accurately assessed this case without knowing that. It's
I
not.
agree, but my question to you was, it is clear that putting up a system that you're not licensed to do is a bad act. Yes, can we agree on that? That's a bad act. You can only put this system if you have a master license, and if you do it, that's a violation of law. That's a bad act.
Okay, but we didn't emphasize necessarily that you were putting up the system. What the people's theory was emphasizing was that the system produced a gas leak and dangerousness, and that is what informed the recklessness of the behavior in going ahead. So,
Which constituted a bad act.
well, okay, I mean, whichever way, if you want to call
Look,
it, I mean, I think it's maybe to some extent semantics. I can understand why the trial prosecutor and the judge thought this was intricately connected.
Given that the judge obviously did not consider it in that way, was his limiting instructions, which I know he gave at the time of the testimony and at the time of the charge, at least twice, was that sufficient?
Yes.
Could there have been anything else he added, as counsel indicated that with the other testimony, he did make it more clear not to go with, be careful about the propensity. Could he have said a few more words that might have helped out here?
Okay, I don't think that would have made any difference in this case. I think the limiting instruction here pointed out the proper probative value of this evidence. And the fact of the matter is the people were not making a propensity argument. We were not arguing.
No, but the fact that you're not making a propensity argument doesn't mean that the evidence cannot be used for propensity. So what you are arguing is not the sole issue that the judge has to consider.
But the crime is the reckless creation of the system that caused this explosion. And this is all part and parcel of the same thing. I think that I think that limiting instructions here are directed to the jury to the proper use of this evidence. And I think that given the overwhelming evidence and that the system both caused the explosion, that it had an inherent flaw, that anybody should create a system like this surreptitiously, keeping it from the mandated regulatory review that's designed to ensure the safe use of natural gas. After the first use of doing so results in a gas leak, causing a massive explosion and death, is so incredibly reckless that the entirety of it, certainly the dispositive thing can't be, oh, the flex hose system. The flex hose system paled in comparison. And in terms of the amount of evidence in this case, they talk about 8 witnesses.
Well, this was a
There were
2 months
60
trial, right?
witnesses. This trial went on for 2 months. So the flex hose system was hardly the centerpiece of this. The centerpiece was the Con Ed testimony, Pacheco's testimony,
Con Ed testimony
expert testimony.
about the flex hose. Counsel, I'm not trying to trick you into a position, okay? I'm not. You do not lessen your argument by conceding that, yeah, this was a bad act and it probably would have been better if the judge had engaged in the analysis, because then you can say, but it doesn't matter. And that's what you're saying to us now. And so this is a bad act, okay? And so the issue for us is, does it matter? Was the evidence sufficient? Were the curative instructions enough so that it safeguarded the propensity arguments that counsel is making?
Okay, well, yeah, I mean, and obviously I submit that it was, and that this is a case where the evidence was overwhelming. The judge made it very clear that the flex host system he's not being charged with anything related to the flex host system. What mattered, and there was so much testimony about this other system, how it was put together, what the inherent flaws were. This system was created in a way it hooked up to a live gas line.
We're familiar.
Okay,
Remember,
so
this case
there was
has
so
been
much
here
evidence
before.
here that this was really a very minor aspect. I don't know if your honors want me to address the severance issue at all, or the sentence issue.
Don't need that. We're really focused on this issue right here.
Okay, we ask that the judgment be affirmed.
All right. And I'll hear you now. I'm going to give you an extra minute.
Thank you, Your Honor. So I think the key here, again, is that this balancing test was not done, which means that the evidence was not limited in any way. All 8 witnesses were allowed to testify. These photos were allowed to come in. There was no parsing of the evidence to say you can have this but not that. All of it came in. And then there was not an instruction given to tell the jury how they were allowed to interpret that. And going to the people's argument here that this was needed for a state of mind or background, I would like to direct the court to People v. Woody, which looks at this. It says the background exception is pretty limited and it can't swallow the rule, and you there's another less prejudicial way to get at that same point.
I'm sorry. On this fact pattern, a building blows up because people put in a system after having been told that the first system was bad and that they required a licensed plumber. Okay? I mean, you can't get around that.
And this was an undeniable tragedy, Your Honor.
Okay? You cannot get around that. So, I wish that this issue had been dealt with differently, but it sounds to me like all of the other protections that would have been put in place had the analysis been done in the proper way were put in place. And I don't see what evidence should have been left out of this background information, because that background information was essential.
Your Honor, in response to that, there were witnesses who testified specifically that this prior system that didn't share the same faults as the one that allegedly caused the explosion was dangerous, right? It was not dangerous for the same reason. Gas is dangerous, we admit that, but they were different in kind. And then, talking to the prejudice about how there was extensive, evidence in this trial, there wasn't a photo of the gas system that exploded. There was only not just one photo, but multiple. There were multiple. No,
it exploded. So of course there's not a photograph, and the defendants hid it.
There were multiple photographs of the system that was not at issue, that didn't look anything like the system that was the part of the charged conduct.
In People v. Cusick, this court walked through the system and what was rigged here very clearly in confirming the conviction of your co-defendants here. We understand what the system was.
I want to thank you, and please extend, on behalf of this court, thanks to your law firm for the pro bono work that they are doing with the defendants' counsel. Thank you so much. Have a lovely evening, everyone.